May I, Your Lordship? Lordship, I beg to mention item number 6, Your Lordship. I've taken concern, Your Lordship. This matter to be listed on 19 of this month, Your Lordship.
19. Yes, Ms. Pipango, learned government advocate for the respondent authorities. We come to the other side, first for listing the matter on
19.
19.
19, Your Lordship.
Receipt of the fair lot.
May I, Your Lordship? Your Lordship, status quo is there, so it may be continued.
Okay.
Your Lordship.
Till then, interim murder first earlier shall continue.
Your Lordship.
Maybe. My lord, this is that PIL, my lord, regarding. So, Lordship. It was just ordered at 8/5/2025. This honorable court was pleased to direct that at every 2 weeks, my lord, status report be furnished before this court. Yesterday, they have filed another one. Apparently, it appears they've trying to, my lord, but they've started at the time, my lord, it's impossible. It's been raining the last 2 months. No, be managed.
Where is the status report?
But we have no an affidavit, your lordship,
Where?
page yesterday, page 382 starts.
And the photographs, my lord, they have themselves annexed. Will reveal what is the condition. I don't even want to make a prayer now. Then at least that stretch from Model Village to Nejuli should be constructed. But now it is raining, my lord. As far as the affidavit is concerned, it is the same excuses. And the photographs your lordship will see what is the condition of the road.
Where is the earlier status report?
Earlier, this report also they filed by the last. Must be in the.
Page 364.
That point of time, my lord, there were no men, no machineries. It appears now, my lord, they have added something to it.
We have clarified that aspect. To your lordship.
Whatever it is, my lord, my learned friend keeps on saying this. Fake remains, my lord, the work has not even been done. It is not an adversarial litigation.
Absolutely not.
Mr. Dubey, we have also been moving in this area. There should be at least some people working. We have not found.
On the last occasion, my lord,
Means you are carrying out work, but we have been also moving. We have also seen such activities taking place in Guwahati, nearby areas. We find huge number of employees working, doing things, but that same pleasure is not got when we move around, when we see the works taking place. 2, 3
2, 3,
laborers,
my lord, 3 at the most.
workers. How do you expect to complete this magnitude of work
No,
by
but-
with this level
2,
of
3, my lord.
engagement?
No, but if your lordship would see the last order, there was.
Forget the order. I'm talking about the practical reality.
No, men have been deployed, my lord.
Where?
Not on the site.
We'll send commissioners now
Yes, yes.
to check up.
Yes, my lord.
Unfortunately, Mr. This is not giving us a very good vibe.
Lord, we understand, Lord, earlier, Lord, there was, Lord,
One contractor did the work, could not changed. Another one has come in. He also same thing. We have not even seen the files coming up. The pillars, fires have not come up. Last time when I was here,
Yes,
not
my lord.
much development. This time when I have come,
Lord, if you Lord, on the visibility, Lord, itself.
very expert, but
No,
comparing it with the work which we see in Guwahati,
But that, of course,
Why?
Lord, there is
it was a working season. Now maybe rainy season, why this works are not taking
In
place?
spite of being rainy season, my lord, we have tried to work, my lord, and
How?
my lord, we have
To
given
show,
them. My lord,
to show, why not in the rainy, when it was dry season, why the works were not carried out expeditiously? When the court is monitoring,
my lord, there were certain issues on our end, my lord, which we have also highlighted, my lord.
that the utilities are not being shifted. Whose response is that? Is it not your responsibility also to see that they do it?
My lord, we have been time and again requesting them.
No, if one thing, if they work, you are not interested, leave it, make it plain, let it be like a village. We don't want a smart city, let it be. But now the smart city concept is creating a lot of problem, more problem for the residents here.
Yes, exactly, man. Last 3 years, my lord. And my lord is absolutely correct, my lord. In fact, now my landlord, he is submitting on instruction. We go through the route every day. Every pillar, my lord, there are not more than 3 people, my lord, not more than 3 laborers.
Maybe it is for the next generation, not this generation.
Maybe. If this is the pace of work, my lord, I can say
My lord,
10
please-
years it
please
will
be-
not be
my lord,
completed, my lord.
When I had the occasion to visit today morning, my lord, from the stretch, my lord, where the traffic has been, my lord, diverted, my lord, the major earthwork, earth cutting work has, my lord, started, my lord. It's been going on, my lord.
Started.
And it is- my lord, much has been, my lord, can, my lord, send a commission to that effect, to that part at least, my lord.
Today morning they were working.
My lord,
Today morning they were working.
my lord, there have been man and machinery, my lord, yes.
How? It was raining.
No, no, if
Get
you
the
also
tops
put the
today.
earth, my lord, where the earthwork is going on, my
Mr.
lord.
Dubey, if you
My
can
lord.
do the work in such rains, why this work was not done when
Yes.
there were no rains?
That is the question.
My lord, it was not done as desired, my lord. That's, my lord, admitted.
Who, you disclose who had desired that?
No, no, my lord. But in terms of the schedule, it was not done. That's what I'm indicating.
You had a schedule to do the work.
My lord.
You are behind the schedule.
Yes, we.
Who desired you not to do the work?
No,
Disclose
no,
that.
it's not that somebody
You
desired.
use
not
the
to do.
word that desired
No,
not
no,
to
no,
do.
Lord, it was not done as per, Lord, desired, Lord, project, Lord, projection. Not as if somebody else, Lord.
And my lord, one
am-
thing I have been harping on, my lord.
Perhaps there was an order of this court to furnish the status report each and every date. Whether it is being filed, status report.
After the last order, yes, 2 status report has been filed.
No, this is
Yes.
general.
Yes.
What my lord is asking is that what work day-to-day basis they are doing, that is not.
Yes, yes, that has not been filed. That was an order by Justice Warren.
My lord, see at page 389, Lord, we have provided the list of details of the machinery, Lord. The number of persons being employed, Lord. What has happened, Lord? On the earlier status report, Lord, we have only provided the detail as regard the additional work that was done for maintenance part. There only we have shown the machinery only for the additional part. There was 1 or 2 excavator. The Rashi was had thereafter, Lord, had sought instructions.
When were these materials and machinery deployed?
Lord, in different stages, Lord. What are the scale, Lord, in terms?
Why? Why was it deployed? When? Last month? Last week?
No, no, Lord, from earlier only.
No, please, Mr. Dubey.
Mr. The works, that machinery and materials you have deployed,
My
say
lord.
you had deployed it 2 months, 3 months back.
My-
How were they utilized?
Lord, in what we are undertaking, Lord, that requirement, Lord.
Only by collecting the materials and deploying the machineries, you have done your work.
No, no, it's not that, Lord.
And my lord, machineries were deployed after the last order, my lord.
No.
Yes, that is, that the, my lord, the representative is here, my lord, may I ask him. That is what I was told, my lord. That we are arranging machining tools and machineries from these and these contractors. The MRT's representative was here. That is what he told me. Machinery is only deployed after that. That is how it was arranged. From local contractors. After the last order, my lord. Justice made his order.
But as per our report, my lord,
And thereafter, my lord, the,
physical progress of the work is 42.
it was all over social media, my lord.
It's not possible to execute that portion of work, my lord, only for few machineries, my lord.
That is exactly why it has not been completed in 3 years.
No. That has not been done, progress is not.
Under
Doesn't mean, my lord.
149 pillars you are supposed to construct. How many have you constructed till then?
16
Then,
plus. No, we are admitting, my lord, that we have been lagging behind in the work.
now
It's
that
not
is
my
another
lord,
thing, but you saying that the machineries have been
It's
deployed from
not that,
earlier
my
is
lord, it's-
incorrect, my lord.
We are not seeing as an adversarial litigation, my lord.
I was categorically told, my lord, I'm making this statement as an officer of the court. And thereafter, my lord, MS Navam Tulon, my lord, was engaged. It was all over social media, my lord. This is after the last order, 2 weeks back, man.
So date
After
of
22/5.
Date of completion is 31st of July 2026.
Date of
Now, can we expect that within a period of 1 year, you will be able to complete the work?
Lord, as per the work program given by us, Lord, we are hopeful that we'll complete by that time, Lord.
Hopefully.
Yes.
Was supposed to be completed on 27th of December 2024.
No, in the
Lord, even
status
in-
report, they
even-
have mentioned it is 31st of July.
Now, after that
But
completion
we have
period,
extended it.
he extended. It was 7th of December 2024.
For how many times it was extended?
I believe this is the first time.
This is the first.
There was absolutely no progress. And my lord, one more thing. My lord, one more thing, my lord. The flyover part, I can understand, my lord, maybe something is going on. But what about the construction from Model Village to Nirjuli, my lord? That part was earlier constructed, half constructed. Now, my lord, sealed, mud, sand, full of potholes. This package B is up to, my lord, from Papunala to Nirjuli, my lord.
Anybody from respondent number 8? The contractor?
Testimony number 8, my lord, TK Engineering.
Yes,
I
sir.
believe the contract has been taken back from them.
Whether the new contractor is implicated here?
Lord, we are representing the
The
respondent.
main contractor is here, my lord, EPC contractor.
And if your lordship kindly compare
Last order to the questions. Second six to them.
What is the distance between Model Village and Nersulis?
Would be around at best 5 to 6 kilometers. From
Whether
Naharla,
any work was taken up there?
work was taken up, my lord. Work was taken up. Initially it was taken up, my lord. It is now totally, my lord, filled with silt because of maybe art cutting and just come down the road, potholes, totally gone. In fact, they have annexed some photographs, my lord. That is self-source. $397, your lordship might kindly see $397 of the report they filed by the respondent number 7. This is the state of the road, man. This is the part, my lord, I'm talking about. 397. It was constructed. It is how it is. Exactly how it is. In fact, this is the better portions they have photographed. Better portions. And if this art cuttings manner that are coming to the road, if something is not done about it, even if it is constructed manner, it will be of no value. There must be some remedy to this also. After the last order, my lord, 22, only this portion was done, 399. Black topping part. The last photograph, the below one. The same photograph, they have added at page 400 also.
I will also look at page 384, at 84, 85, 86.
Yes, Mr. Ratan, you have received the status report,
Yes, madam. With regard to the deployment
391 page number.
391, my lord, that status report, we have not received.
Regarding the hindrance,
Hindrance.
No, my lord. This status report.
ये पहले बताएं, ये पार्ट बताएं।
But that, what status report is our status report with regard to the deployment of machineries, laborers, my lord, men and machineries, as per the last order. In fact, in the earlier status report, the deployment was less. Now, subsequently, they have deployed some more, my lord. These hindrances, my lord, are basically in between the town area for the flyover part. Fact remains, my lord, model village to, my lord, New Delhi is encumbrance free. Something has to be done about that at least, man.
so then status of that area that Nirjuli to model place,
Nothing is going on.
nothing.
Not a single laborer is there. Engaged. Nothing.
Silt is coming from the beyond the ROW block. That is the difficulty block. Now, we are supposed to start that part also, because on last occasion also my friend had highlighted that aspect of them. Because of the rains and all, my lord, we have also indicated the kind of rate we had in last 2 weeks. We have to
Can't understand this, my lord. Completion period was 7th of December. That was working time. They didn't do anything, and now, my lord, making this some excuses. I'm
last
sorry
1
to
month,
say
my lord,
this.
more emphasis was on the maintenance part of it, my lord, because of the rainy season. Still, the my lord, the long-term work is also being carried out. That's what we are, my lord, doing it part by. My lord, one part, maintenance part of it to the extent, my lord.
So suggest us.
My
What to do?
direct them to continue, my lord, with the, since your lordships are monitoring this now, then after next 2 weeks, it will be listed again. There is already an order fixing this every 2 weeks, my lord. That is all we can hope for, that they do something.
That's all right, but on earlier occasion, they have not filed the status report regarding the progress of the work.
Yes,
both,
my lord, we will
physical
pass
and
necessary
financial.
orders, man.
Why? Each and every day, let them file their.
Yes, yes,
status
yes,
report.
man.
What is the financial progress and the.
Yeah.
That is
physical
there
progress?
in our report, my lord, if your lordship sees. At page 384, my lord. regarding the details of the project.
Mr. Pandey, earlier we have constituted one committee of.
Yes, yes.
What happened there?
My lord, they submitted a report saying that there was absolutely no progress. Yes. My lord's order, my lord, committee furnished the report. It must be in the record, my lord.
So whether the committee is in a position to furnish a report on each and every date when the case is listed before the court?
My lord, that I am not sure, my lord, no, Mr. Apam is not keeping very well also. Maybe some other, my lord may constitute a new committee, my lord, Mr. Apam is not keeping.
But in fact, after considering all these aspects, your lordship intended to monitor this floods bi-weekly. That's how we were directed to furnish status report for the work that has been done for period to period.
My lord's suggestion, my lord, if,
Yes.
as per my lord, sir, if that can be advocates, that would be my lord better, my lord. At least some true picture will come before this honorable court,
Yes.
not this affidavit.
Exactly what has happened here,
Yes,
it was happened in Nagaland also.
yes, yes.
Under the monitor of the court monitored project, it was completed within stability.
Yes,
project.
yes. Man, that can be done, man. They will keep on filing their reports, my lord, and advocate commission can also, my lord.
Justice.
Then you suggest a person
Mr.
Yes,
Tapo and Miss Duncan was already a part of the committee. Somebody else maybe, my lord. Mr. Son, my lord, may lead the commission, my lord, along with the earlier two committee members,
yes.
Mr. Tapo and Miss Duncan.
When we have passed that order, the last part of December. perhaps.
Advocate commission. Order.
Heard Mr. D. Panning, learned counsel for the petitioner, also heard Mr. N. Ratan, learned additional advocate general, Arunachal Pradesh, appearing for the response numbers 1, 2, and 3, and Mr. R. Dubey, learned counsel, appearing for the response number 7. In terms of the directions passed by this court, the contractor, response number 7, has filed a status report. Also, Mr. Pani, learned counsel, appearing for the PIL petitioner on perusal of the said report, has submitted that the same is not, the progress demonstrated therein is not satisfactory. He has further, on his personal note, submitted that on moving through the area wherein the works are being so executed, it was found that very few personnel were involved in carrying out the works, and accordingly he submits that if the progress of the work is so carried out, the same would not be permissible to be completed even after completion of the date fixed in the contract for the extended date for completion of the same.
312 is the order.
Complete those. In view of the dispute brought on record with regard to the progress of work being carried out, we are of the considered view that the committee appointed by this court in the present proceedings, committee of advocates appointed by this court wide order dated 3/12/2024 is required to be revived and requested to monitor, to visit the area, inspect the area, and furnish a detailed report to this court on the next date of listing. Full stop. This court wide order dated 22/5/2025 had noticed the submission of Mr. Pani that with regard to the area falling between Model Village to Nirjuli, there was no hindrance for executing the work in question, in as much as the public utilities therein have been removed and would not be a hindrance for executing the work by the contractor. This court had also noticed in the said order that the Learning Council for the respondent number 7 had assured on instructions that the work for the portion from Model Village to Nirjuli would also be taken up in right earnest. Mr. Panning has submitted that for a certain area, there has been some work done, like blacktopping of the roads. However, for the entire stretch, the work has not progressed as desired. The committee of advocates would also inspect the area from Model Village to Nirjuli and submit its report to the status of works being executed therein. It has been stated in the bar that Mr. Azing Aping, Learned Senior Counsel, is not keeping well, and accordingly, he, for the time being, be replaced by Mr. Mr. T. Son. The said committee would work under the chairmanship of Mr. T. Son and would involve Mr. P. Tafo and Ms. N. Dungan, advocates. The report of the committee of advocates be furnished in the manner indicated herein above on the next date of listing. Registry to list this matter again.
Physical progress.
My lord, as per the order 8-5, my lord, date of listing is already indicated.
19/6. But by.
Come up on, my lord, 19-6.
Where is the financial progress report?
Lord, in that same, Lord,
Where?
we have shown both physical and financial together there. In the same table, you also would see physical progress is 42.69, 384. And financial progress 42.05.
Right? Okay. On the report, filed a report. So, a perusal of the report indicates that physical progress of the work has been achieved up to 42.69%, whereas financial progress has been so achieved up to 42.5%. Also, the progress report, physical progress report of the project as indicated in the said status report is extracted herein for ready reference. Page progress to do taxes.
You have not shown
Financial
this,
separately.
No, we have the percentage of work done. The progress that has been not taken, you will also find from 384 onwards as regard the various stretches.
Okay.
Progress of the work,
Eight.
progress of work and drain, then project for work program.
Page 388 of it. 384 to 388. The committee of advocates would assess the progress of work, progress of the project as set out in the status report and extract by the contractor and extracted herein above with the help and assistance of the chief engineer.
No. Chief engineer or executive engineer.
Executive
Highway division.
Highway
Division, Narla.
Highway Division,
Narla.
Naharlagun. And would also incorporate the same, incorporate a report regarding the same in their report that would be submitted before this court.
Can I make one point? Lord, the area in which we are walking, Lord, they also see, Lord, in that.
They are going to see everything.
Only Lord's indicated.
I have said, we are not
Only
bound up.
indicated
It's
the entire area.
it's only
Yes,
it's in the name of the advocates, but it's a public committee.
Yes, absolutely. Lord, we will
They are
not-
there as citizens residing in that area,
But
not
where-
as advocates.
Lord, where we
Yes,
are.
Mr. Pani?
Yes, but
Yes,
in
yes.
fact, I reside, my lord, where it is supposed to be starting now. Lord, my lord. It is supposed to be listed on, my lord, 19-6, my lord, as per the order at 8-5.
Your Lordship says order dated 8/5.
The registry to list this matter again on 18-6,
19, man.
No, 18, we have to file our report.
Status report by 18.
19-6, 2025.
My please, your lordship. Lordship, we have received the status report.
It was served.
Yes, your lordship. In fact, the OC of the police station has given to the superintendent of police the served copy of the case here, the served copy to the informant, your lordship. Usual process is the OC give it to the SP. The SP then through registered post give it to the register of the High Court, your lordship. However,
No,
this
that's all right.
this
Now you
implicates.
Now you tell us whether it was served upon the
Yes, yes,
respondent.
yes, yes.
Yes.
It has the forwarding has clearly states that it was served to the informant, your lordship.
So then we have to appoint an amicus curiae.
Yes,
a
your
legal
lordship.
aid counsel
Yes.
to represent the case of the respondent.
Yes, your lordship.
Lordship, my small prayer, Lordship. I may to allow the amend the post title. So I need 1 week time.
1 week time.
Yes.
Okay. Or Mr. T. Topol, learned counsel for the appellant, and Mr. Zeni, learned additional PT for the respondent. Then Mr. Bhattacharya for respondent number 3. Pursuant to order dated 4/6/2025, Ms. Zeni, learned additional PT has obtained a service report in respect of service of notice upon the respondent number 2. Respondent number 2. But no one entered evidence on behalf of the respondent number 2. Accordingly, it is provided that
Appointment of amicus, your lordship.
suggest one name who is regular in the court
Your lordship.
and who has also experience.
Ms. R.
But,
N. Dangan, your
But
lordship.
his or her name should be there in the list, in the order.
N. Dangan,
N?
she's the amicus. N. Dangan, your lordship. Nikita Dangan.
Her name is not there.
Amicus. Amicus. Gaken Jini is there, your lordship.
Pardon?
Gaken Jini.
Serial number
Serial number, your lordship, 12.
12.
Yes, your lordship.
Okay. Accordingly, Mr. Zikin Zini, learned advocate, is engaged, is appointed as legal aid counsel to represent the respondent number 2. Races shall reflect the name of Mr. Z. Zini, learned counsel, learned advocate, as legal aid counsel in the cause list, and furnish the relevant papers along with the paper book to him well in advance, and leaves the matter after 1 week.
Yes, your lordship.
After 1 week, the learned counsel for the appellant further submits that there is a requirement for amendment of the cause title of the appeal, and he prays for granting him 1 week time. Here is accordingly allowed. Rest is unless the matter after 1.
Detail.
Am I audible, Your Lordship? Your Lordships, I am appearing in item number 3 for the appellant.
Appellant,
Your Lordship, yes, your Lordship, my IA for suspension of the sentence has also been listed today. Your Lordship, in fact, there was a confusion. It has been listed after a year. My application for suspension of sentence.
You see, the matter is ready for hearing. Therefore, we will take up both the matter together. You can
Your
argue
Lordship, then in
the
that event,
matter on merit.
Your Lordship, in that
Pardon?
event, I would be physically present before your Lordship and then
Yes.
address, because this is a 302 matter. Your Lordship, in that event, I would require to be assisting your Lordship physically by being present in court. Your Lordship, then in that event, as per your Lordship roster permits, your Lordship may fix a date in June after 24th. And I would request for a fixed date, your Lordship.
Okay. After 24th of June.
After 24th of June, any date after 24th of June.
Pardon, sir, your good name, please?
Chetan Joshi.
Ketan Joshi,
Chetan
learned counsel
Joshi.
for the learned counsel for the appellant. Price for listing the matter after 24th of June. On which date he will physically remain present in the court to argue the matter. Where is accordingly allowed recessal list the matter on 26th of June.
Please, your Lordship.
Okay. Then Mr. Tado, learned additional people for the state respondent present. Anybody for this respondent number 2?
Legal aid counsel.
And amicus, legal aid counsel and amicus was also appointed, your Lordship, as per the last order.
Legal aid counsel. Hinti Jaram.
Is she present?
Integer and by the order dated 13/3/2025.
Not seen today.
Okay. None appears for the respondent number 2. Though Ms. H. Zeram, learned counsel, is appointed as legal aid counsel to represent the respondent number 2. List the matter on 26th of June 2025.
Deeply obliged. Deeply obliged, your Lordship. With your Lordship's permission, may I leave the meeting, your Lordship?
Pardon?
May I leave the meeting with your Lordship's
Yes,
permission?
yes. Yes, so what was the matter here?
Your Lordship, if your Lordship on the last occasion has there was an issue with regard to registration of the birth certificate, your Lordship, under
Yes.
section 3, your Lordship.
Yes.
Deaths and birth registration. Deaths.
Here it was issued the municipal law.
Yeah, register issue.
Register date-
Register
date and birth.
date births, yeah, that's the two. Under 12. Himachal Pradesh registration of births and deaths rules 2001 millions. Arunachal Pradesh registration of births and deaths rules 2001. Of births and deaths rules 2001. Thank you.
So the learned trial court has relied upon section 35 of the Evidence Act.
Evidence Act, Your Lordship.
So that process is made by a decision of Supreme Court in year 1965. Supreme Court 282. So is there any difference in the transfer certificate and the birth certificate? There is one transfer certificate. Is there any difference of date of birth in between the two?
Yes, Your Lordship, but then the leave certificate is, the date of birth written in the leave certificate is in comparison to the birth certificate filed during the admission, Your Lordship. That is only a reflection, Your Lordship.
Birth certificate of whatever is it, 17. Transfer certificate to full 2023, date of birth 18.
Anyway, we'll see you complete your argument.
Yes, I have certain citation, Your Lordship, if I may be allowed to place, Your Lordship.
Hmm.
This is a citation of our own High Court, Your Lordship. The same issue was dealt with, Your Lordship. Lordship, it's 2021 3 GLT 128, Your Lordship. My reliance is at paragraph 27, Your Lordship. If I may read, Your Lordship.
Paragraph number
Paragraph 27, Your Lordship.
27.
8-6.
Yes.
If I may read, Your Lordship. From a close scrutiny of the materials available on record, we find that Exhibit A is the photo compared with the original of the birth certificate issued by the Department of Health Service, Government of Assam, certifying that the accused was born on 25/8/2001. This certificate was apparently seized by the IO in presence of two Caesar witness, so and so. However, none of the Caesar witness have been examined by the prosecution during the trial. Birth certificate Exhibit A was in fact exhibited by the informant PW1, who is the uncle of the victim, Your Lord. Now, if I may take, Your Lordship, then to paragraph 29, Your Lordship. If I may read, Your Lordship. From a plain reading of section 35, it would be apparent that an entry made in any public or the other official book, register, or record is required to be proved by the public servant who has made the entry in discharge of his official duty or by any other person in performance of his duty, specially enjoined by law. In instant case 8 noted about, no officer of the department was summoned by the prosecution as a witness to prove Exhibit A. Paragraph 30, Your Lordship. It also appears from Exhibit A that subject was born on 25/8/2001, but the birth certificate was issued on 12/7/2012 after a period of almost 11 years. As per section 13(3) of the registration of the birth and that Act 1969, any birth or death which has not been registered within 1 year of its occurrence can be registered only on an order made by the magistrate of the first class or a preceding magistrate after verifying the correctness of the birth and death on the payment of the prescribed fee. Now, Your Lordship will then come to paragraph 32, Your Lordship. In the present case, the prosecution has made an attempt to prove the document Exhibit A through PW1. Your Lordship will see PW1 is the uncle, Your Lordship. And it appears that the defense side did not raise any objection when the document was marked as an exhibit. Therefore, insofar as the admissibility of Exhibit A is concerned, the said question must be answered in favor of the prosecution. That, however, would not automatically absolve the prosecution from requirement in law to establish the truthfulness of its content. The PW1 being the informant in this case had nothing to do with the birth of the child or the Department of the Health Service Assam. Therefore, in our opinion, he was not competent. Now, in this case, Your Lordship, the Exhibit A, which is the birth certificate issued by the Health Department, Your Lordship, that was never, the delay of obtaining that was never, the question of obtaining it on the later stage was never taken into consideration by the defense during the trial, Your Lordship. Subsequently, Your Lordship, the court has said that the said question is therefore, since that was never raised in the trial, Your Lordship, the benefit was given to the in favor of the prosecution, Your Lordship. My contention here is, Your Lordship, in this case, PW1, who is the uncle, who is not the issuing authority of the death and birth certificate, since he was not an authority, Your Lordship, his contention that the birth certificate was issued by the Department of Health was not considered. However, in our case, Your Lordship, the birth certificate issued by the statistic office was substantiated by the evidence of the video, Your Lordship. If Your Lordship will see the statement of the video, who is the PW8, Your Lordship, which is at page number 67, Your Lordship.
Yes.
Your Lordship will see that, if I may read from the third line, Your Lordship. I am BDO Nafra and in charge of ADC cum registrar birth and death Nafra. As per the record of the date of birth of victim child so and so on so and so, exhibit was before him was his original birth certificate of the victim issued by the office of the registrar, and that for a seal and signature of the registrar birth and death Nafra, which I can identify. Exhibit A is affidavit sworn by the mother of the child before executing magistrate Nafra declaration of date of birth of the child, and 8A is the seal of the magistrate which I can identify. Exhibit 9 is Form 7 regarding birth registration. Then next page, Exhibit 10 is the birth register maintained by my office, consisting of 2 pages compared with original, and 10A is the seal and signature of then registrar of birth and death. Now he has identified the issuance of the birth certificate. My only contention for relying on this case citation is that even if the delay was made, Your Lordship, it was never raised before the trial court during the trial, Your Lordship, and therefore the division bench has said that the question must be answered in favor of the prosecution only on that fact, Your Lordship. And secondly, that though in this case the fact is different, that the PW1, who is the uncle, has not issued the death and birth certificate, but in our case, to corroborate with that document, Your Lordship, it was substantiated by the statement of the BDO, Your Lordship. Now Your Lordship will see that Section 35, since this is a record of this is a public document, therefore Section 35 of the evidence was relied upon, Your Lordship. Now, if I may.
Yeah, please, madam. Madam, in this case, the appellant has been convicted under 376 and 302 solely on the basis of relying on a DNA report, my lord. Otherwise, if you peruse the statement, a deposition of the prosecution witnesses and the co-accused, my lord, there's no any inculpatory statement implicating the present appellant for the commission of offense. There's no CDR. The appellant was nowhere found in the place of occurrence. It was only on the basis of 2 DNA reports. There were 2 DNA reports, in fact, madam. The first DNA report, which was taken after the arrest of the appellant, that came to be negative, madam. Now, the second DNA report, which was taken after a lapse of 5 months, that report came to be positive, and basing on that DNA report, the appellant has been convicted, madam. If I may read the FIR and the deposition.
No, while the first sample was collected,
My lord,
that was found to be not suitable for analysis.
in respect of that, madam, yes.
Yes.
Yes. Now, the second
And
DNA
therefore, the report came to be negative.
negative, madam.
And thereafter, the second sample was collected.
Yes, madam.
And it has been found to be positive.
Yes, madam. Now, my lord,
What wrong with it?
my lord, the messenger who was entrusted to hand over the samples to the laboratory was never examined before the trial court. The
So,
director,
Why it is necessary?
my lord, the director to justify the integrity of the sample, since that was, the samples was under the custody of that messenger before he furnished it to the laboratory. And the director DFS Assam has not been examined. So to justify the integrity of that sample, my lord.
No, is it, there is a provision in the CRPC that without examination of the expert, the report can be accepted?
Even otherwise, my lord, my contention is that whether, even if we presume that that DNA report is right, my lord, on that account itself, whether in isolation, whether the appellant can be convicted in absence of any other corroborative evidence, my lord. That is my contention in this case, my lord. if we peruse the deposition, my lord, chief, and the cross-examination, there is not even a single statement against me, my lord. Solely
So,
on the DNA report.
how the blood sample of the appellant was matched with the with whom
With
what
the-
it was
of-
matched?
Of the victim, my lord.
Victim.
Victim, my lord.
Yes. So then prosecution has discharged their burden
Pardon.
that it is your sample that has been found in the person of the victim. So now you have to explain
My lord.
how your sample reached there.
My lord, it was the prosecution who has taken the sample, my lord. It was the scientific expert
No.
who has received the sample, my lord. My lord. My lord, even for a time being, my lord, I'm doubting the
So
authenticity.
that's all right. The only the FSL report may not be sufficient to establish the prosecution
Well,
can beyond reasonable
My
doubt.
lord, my lord.
But the thing is that burden is shifted to you.
Yes, my lord.
While the prosecution has established that the sample found on the person of the victim
My lord.
match with your DNA.
My lord. But I'm doubting the manner in which this second DNA was taken. But apart from this, my lord, my only ground is that even let's presume that this DNA report is right, my lord.
Yes.
Now, in isolation, on the basis of this DNA report, whether an appellant can be
That's
convicted
why
in a
obviously
serious
the-
offense. My lord. If I may take my lord to the FIR. Of the paper book, my lord, if I may read. FIR dated 29/8/2012. This is to inform you that my daughter, Miss So-and-so, aged about so-and-so, was found missing with effect from 28 August 2012 evening. To have out my missing daughter in nearby villages, and relatives have been informed, and a search operation was conducted in the night of 28 August 2012 in and around all the probable places of my village, but failed to trace her out. Again, on the search operation was launched today on 29th August 2012. Early in the morning, and my missing daughter was found dead nearby the jungle of Sharo village, near so-and-so, in between so-and-so village, under house circle, with blood stains, injury marks on her body parts. It is suspected that some miscreants have tortured and killed her. It is therefore requested to investigate the matter and culprits put as per the provision of law. My lord, on the basis of this FIR, my lord, altogether 8 persons were arrested. And after completion of the investigation, my lord, the charge sheet was filed. And eventually, my lord, all 8 accused were on trial, my lord. And thereafter, eventually, on the basis of this DNA report, the present appellant has been convicted under 376 and 302. Now, if I may take my lord to the deposition.
whether the blood sample found in the steering and inside the Alto vehicle was
Taken from the police station, my lord.
police station.
Police station. My lord, if I may take my lord to the deposition, my lord, chief, and the cross-examination of the. That will start from my lord, page number 169, my lord, of the paper book.
Yes.
PW1, my lord, on auth. My lord, before I go through with the deposition, my lord, the name of the appellant is Pasang Tashi, my lord, the client. I have come to this.
So other persons, other convicts have not prepared any of it.
My lord, they have been acquitted, my lord, rather than a trial court. my lord.
You have submitted that 3 of them were convicted.
No, my lord, only one out of 8, my lord. I have come to this in connection with the case related to my deceased daughter. I left my workplace in the evening at 5 p.m. The date of the said incident was 28, but month and year I do not remember. After reaching home, I did not find my daughter. I was looking after the sick younger daughter, and my wife, along with Lama and one girl, went out looking for the missing daughter. Later on, some more people joined them. They called the friend of this missing daughter to know her whereabouts, but in vain. They searched all the main roads and the villagers, but could not trace out the said missing daughter. Mid at night, the people who were searching made a call to me, for which I told them to stop searching at night so that they start searching early in the morning. Early in the morning, I went out searching of my daughter. And while doing so, I saw a mark which seems to be a mark from where a person had been dragged. So I further looked down and saw the tiffin box of my missing daughter. And on further looking down, I saw my daughter lying naked except a banyan and an underwear up until knee. I found except a gompa nearby where I went and called the lama to help me. I called my wife from there with the help of the mobile of the said so-and-so and told her to come soon with the blanket as the said missing daughter is found and lying dead in a naked position. We all waited till arrival of the police. Since it was a police case, we did not want to go down and tamper the evidences. Later on, the police arrived and see some materials, evidence like empty bottle of rum and cigarette packets. Paper exhibit 1 is the complaint which I lodged, and paper exhibit 1A is my signature on it. I lodged a complaint wherein I mentioned that the dead body of my 15-year-old daughter who was found missing is now traced out hence. Matter may looked into by the concerned officer. I have this much at this stage. Cross was declined, my lord. PW1 is the father. So now PW2, my lord. Page 171. I have come to this court to give my statement in connection with Miss So-and-so since deceased. I gave my statement to the police officer in connection with the case. I know the 3 of the accused persons standing on the dock. Out of this 8 accused persons, they are namely, now these are the accused persons. They are namely Raju Lama, Papu, Tenzin. This accused person whom I know are originally from Nepal, but at present they are residing at Krimu village. On 28/8/2012, I received a missing case. I am a village authority. In fact, my house is located away from the village, but I joined the search operation. The name of the missing girl is so-and-so. The girl was found missing at Lao area. I, along with 4 youths, reached the house of the father of the victim as soon as I got the message. I reached at around 9 at night. It was raining, so we thought the missing girl might have fallen down from the hills, but we went to the spot where some people met the missing girl on the way. These people met this missing girl at around 4:30 p.m. in the spot. We went searching from that spot. We saw Raju Lama in his car. By then, just 60 meters away from the said spot, my lord. Raju Lama. I wanted him to stop his car as he was coming from opposite direction. He stopped his car a little away from the place where I was standing. I told Raju Lama about the incident of missing girl, on which he replied that he also know the missing girl. Hence, he said that he will inform us in case of she is found on the way towards India Gate, as he was going that side looking for 2 friends who were on bikes, 2 bikes. After 30 to 40 minutes, said Raju Lama came back to this Alto from India Gate. I wanted to know from the driver of this Alto as to why he is moving to and fro at this night time. He did not stop his car where I wanted him to. Rather, he went distance away from the place where I was standing. He had to stop his Alto because there was a van parked in the middle of the road. I went nearer to him, for which he opened his car window and told me to check his car so that he is not blamed tomorrow in case anything goes wrong. I found one more person sitting in his car, which is seen here in the court and standing on the dock. In our team, there were 2 girls and one of them new accused person called Tenzin. As this girl used to cook in a company of which this accused person is driver. The girl who was with us and who knew accused Tenzin made a call to him and got it confirmed that the accused Tenzin is present at the residence of one Sri Tring Tashi, who is located at Lembardung. This accused called Raju Lama told me to check his vehicle, though we did not say that we want to check his vehicle. We went back home from there at around 12 at midnight. The father of the victim shouted loudly from the spot where the dead body was lying and made us known about the finding of the dead bodies by himself. This is how I went to the place where the dead body was lying and saw the same. We did not go to the place where the dead body was lying, as we did not want to disturb the evidence since this was a police case. I saw that the dead body was lying facing down and was naked. We went to the place of Raju Lama, as he was found moving here and there at the mid of the night when we were also searching the victim girl. His moving here and there made us suspicious, as the dead body of the missing girl was found down the road where the said Raju Lama was found moving to and fro. So, my lord, we went to the place of Raju Lama and made an inquiry. We saw that Raju Lama was injured. Raju Lama was injured as he was having injury marks on his face. One of the accused standing on the dock also made his appearance by then, and he also having a scratch mark on his face. On asking, Raju Lama told us the same thing which he told at night, that he went to and fro on that road searching the co-accused. This Raju Lama also told us that he met an accident with his car, hence he sustained injury. This co-accused called Tenzin was asked to be at the place where he is supposed to be, as I told him that I am coming to him to make an inquiry, but he said that he was going to on duty. I restrained him from going to his duty. He, instead of meeting us in the place of the wife of so-and-so, met us at the opposite of army workshop. He told us that he was with the accused Raju Lama and others last night before he left for his place, as he was the lone driver of the said madam, and as he might have some wolf with her. He told us that since Raju Lama and others were told by him that he was going back to the place of his master, that the question of searching him at India Gate at midnight does not arise. This has created some doubt. Accused Raju Lama and others were seen at India Gate on the day of incident. They were seen taking drinks, liquor at so-and-so, Leptang, and then so-and-so. These people told us that accused were moving on that day in that area where the incident took place suspiciously. The victim of this case was school-going children reading in class 7. She was of 14 to 15 years old. Later on, I could learn that this accused used to tease the victim girl. And in this connection, the police has also recorded the statement of classmate of the deceased, my lord. Now the defense, my lord, cross-examination. I'm the village, I'll skip the defense part for a time being, my lord. See the deposition, my lord. Sorry, my lord, I'll just go through again. 173, defense. I'm the village authority of Sharo village since 7 years. My jurisdiction is limited within Sharo village only. The victim girl hails from Jumba village, which comes within the jurisdiction of Sharo village. I'm residing in this village permanently. I do not know, but the accused person whom I know must be residing at Primo since last 10 years. I know the father of the accused Raju Lama, who is residing at the said village since last 20 years. Yes, I admit that the accused Raju Lama must have been residing since 15 to 20 years in the said village. I have not come to know that Raju Lama, along with his other 2 friends, have committed any offense except the present one. The dead body of the deceased is found in the place called Nyupsingpu. We were searching at Lao area because this was the only place left to be searched. This victim girl is met by a nun and monk while she was coming back from her school. The place where she is met is known as Sikminia of Lao area. They met her at around 4:30 to 5 p.m. We went to India Gate looking for the missing girl at around 8 to 8:30 p.m. We met Raju Lama at around 9:30 for the first time. I have not seen Raju Lama having talked with the deceased or having moving around with her. While coming back from the India Gate, stopped by his car 30 meters away from where I was standing. We all, the members of searching team, saw the van which was parked in the middle of the road, and there were some laborers numbering from 4 to 5 who also saw the same parked van. At around 11, the said van was in fact parked in the middle of the road to ask these laborers about the missing girl, but the engine of the said van was not put off. Accused Raju Lama told us that if he needed, he may be called anytime for making any inquiry pertaining to the missing girl. We became suspicious because he was moving here and there at night, and whereas there's no office at India Gate nor any shop, more so he was not having any relative there. This is how I stopped the car to know the reason why he is moving by the car at night. Thereby, Raju Lama told us that he is looking for his friend Tenzin Minor, one of the co-accused. We made a call to confirm the whereabouts in the night in the present accused, Raju Lama. We were there at the place where Raju Lama is stopped from 11 to 12 at midnight. We made a call to Tenzin, the co-accused, from the mobile of Lama Jumba and also from the mobile of Tenzin Lama. Maybe the call records of these mobile numbers were given to the concerned Ayuba Ayas. Maybe there were more people apart from the accused Raju and his 2 other friends in the party, which was thrown on the occasion of purchasing a new bike. The injuries found on the face of Raju Lama in the morning by us must have been sustained after we interrogated him at night. The accused Raju Lama told us in the morning that his car met an accident in Namit village, which is 12 to 13 kilometers from the alleged place of occurrence where he sustained injuries. The other accused who sustained injuries during his accident and had a scratch on his face is standing on the top. I know him face, but not by name. We have come to know that Raju used to tease the deceased from the school friend of the said deceased, as a statement of that class friend is recorded by the police. I do not know the person who gave the statement. We have not heard about the teasing the said Raju Lama from any other person except the said class friend of the deceased. I stated before the police about the meeting of Raju Lama in the said night on the said road, and apart from this, I did not say anything before the police. Re-examination, I stated before this all the deposition which I have made here today, but maybe police did not record all this and I cannot say as to why so and so. So far, my lord, there is no mention of the present appellant Pasal Tashima. This deposition, my lord, his statement speaks about the accused who was acquitted, Raju Lama. Now, page number 177, prosecution witness 3. 177. I have come to this court in connection with the rape case of so and so. I gave my statement to the police in connection with this case. At around 7 p.m., once reached so and so, inform us that so and so is missing. On getting the missing information, we started searching her towards her house, which is located on the top of India Gate. We went looking for a missing girl beyond her house towards India Gate because we were of the impression that the missing girl might be there in labor camp watching TV, as this labor camp is located near the house of missing girl. We could not locate the missing girl there at the labor camp, though we made an inquiry into 2 or 3 houses of labor camp. We rather were informed by the parents of missing girl about other groups who were involved in the search operation. As it was getting late, we decided to start our search on next day in the early morning. We met one Shri Raju Lama in the auto. While departing, he was going towards India Gate. When we asked Raju Lama where he is going, then he told us that he is going towards the India Gate looking for his friend Tenzin, who is supposed to be on the bike. We met the other groups who were involved in the search operation on the way. Then and there, we decided to go up to the police, a place called Gamchin Bra, where the missing girl was seen for the last time by the monk called so-and-so and so-and-so. The owner of the said Alto, Shri Raju Lama, came back again from gate. We decided to stop him and so we did, but he did not stop his car. There was a van parked 10 meters away from us. The said person, Raju Lama, stopped the car near the van. On asking, Raju Lama told us that he's looking for Tenzin. Hence, he told us that his car number may be noted by us if we have any doubt on him. Among us, there was a girl called so-and-so who had the phone number of the said person Tenzin, whom Raju Lama was looking for. She made a call to Tenzin to know about his whereabouts. Tenzin then told her that he is by then was at the residence of Sri Sringtashi, the present MLA of so-and-so. Raju Lama was already left when the call was made to Tenzin by us. Thereafter, we were left for our hometown. Early in the morning, we came to know that the said missing girl is killed and thrown away in the place which is 100 meters away from the place where we met Raju Lama for the first time. I did not see the dead body closely, but from the road, we were asked to go and make an inquiry about the incident with Raju Lama. We accordingly went to the place of Raju Lama, who went inside the room when he saw us. When we reached there, some Nepali people told us that the missing girl is taken away by her father early in the morning. We did not tell Raju Lama about the death of the missing girl, but we asked Raju Lama why he was looking for Tenzin last night. Raju Lama answered us that Tenzin was with him in the daytime, but he suddenly disappeared. Hence, he was looking for Tenzin. Raju Lama also told us that in the daytime, he was with 3 other friends like Tenzin, Bapu, and I do not remember the name of the other person at present. He made a call. He was made to call Bapu by us. Bapu told us that he was with Raju Lama in the daytime of the incident, and also he told us that he and his friends had liquor at India Gate with Raju Lama. He also told us that he was with Raju Lama and other friends till so-and-so at night, and they took liquor again there. When we asked him about the time, he told us that he did not remember the time, but he told us as he was at Yangla Gompa till 9 p.m. with his said friends. Bapu told us that thereafter he went home and did not know where Raju Lama went out thereafter. Raju Lama also told us that one of his friends who was with him as an Assamese who used to cook for Graf. We found blood stain on the knee of Assamese friend when he was called by us, and he told us that the blood is there maybe due to biting of the leech. The leech is available there in the place where we met Raju Lama at night. The leeches are found in the area in summer season, not in winter. The leech bite may happen when one goes inside the jungle, but not in the house while traveling in the car. Bapu thereafter took permission from me to allow him to go to market for purchasing stationers for his children. Accordingly, he went to market and told me that he has learned that the said missing girl is killed and thrown away near the labor camp of one Sri Getu. Bapu was not told about the death of the missing girl by us. He told us that the name of the person who told him about the death of the missing girl, but I do not remember the name of the person now in the court. We thereafter had a contact with Tenzin, and he was made to stay back at Bungalow by us through 1 GB. The said person Tenzin was reluctant to stay back at Bungalow, but as we insisted, he was there. When we were about to reach the Bungalow, he has met on the way to Bungalow. We learned from Tenzin that he really was with Raju Lama and his friends in the daytime of the incident and had liquored with 2-3 places together. He told us that when we were taking liquor at Yangla Gompa, Raju Lama and one of his friends went away. He also told us that after Raju Lama and his friend left the said place, leaving Bapu and others there at Yangla Gompa. We were told that on the way to Bungalow, Tenzin was stopped by Raju Lama and he was forced to stay back with them. But Tenzin, being the lone driver of his madam, anyhow convinced Raju Lama and went away towards Bungalow. Thereafter, he told us that why should Raju Lama go towards India Gate looking for me when he knew that I left for my Bungalow. He told us that if Raju Lama really wanted me, then he should come to me at Bungalow. Thereafter, we left for our own place. We can say that Raju Lama was lying. This is because Tenzin has told him that he was going towards Bungalow. The name I have taken like Raju Lama, Tenzin and Bapu are present here today in the court, and they are standing on the dock. I cannot remember the said cook by face now, but I will not be able to recognize him by face, even if he is produced before me. Well, so far the deposition is concerned, and as well as the cross-examination, my lord, they are only talking about 3 persons, my lord. Raju Lama, Bapu, and Tenzin, my lord. The appellant is nowhere mentioned so far the present deposition is concerned. Now straight away, if I take my lord to page number 183, my lord. Mary. I have come to this court for my brother Pasan. I said brother is standing on the dock. I have given statement to the police in connection with this case. I was informed that my child is sick, so I came back home at 2 p.m. On the day of the incident and found my brother Pasan present at home. When my mother came back in the evening, the said brother was sent to market to fetch milk and came back home. Thereafter, my said brother was taken away from home by two of his friends, one of whom I know that he is Tenzin standing on the dock. I do not know if the other accused person is standing in the dock or not, as I have not seen him when they came to take my brother. My said brother went out with them in that evening at around 6 to 7 p.m. Thereafter, he did not return home as he was living at Krimo. I did not bother to make an inquiry about the whereabouts of my said brother. My husband's name is Dorka and he is from Assam. The said husband is not present in the court. Declined, madam. Number 185, madam. I have come to this court for my son who is standing on the dock, but I do not remember his name as he is my stepson. When I came back from my work, he was present at home. The accused standing in serial number 3 is my stepson. The said accused person is pointed out by this deponent as her stepson, and when this court asked the said accused person standing in serial number 3, then he told his name is Pasang Tashi. The police asked me about my son, for which I told the police that the said stepson came to my house and left my place around 6 p.m. and not to be returned again, my lord. This is the statement of the stepmother, my lord. Now, my lord, 186. I've come to this court to give my evidence. I know all the accused persons standing on the dock. I know their names. I saw 4 accused persons going on 2 bikes towards the house of the victim, my lord. These 4 persons accused standing on the dock were going towards so-and-so's house at around 1 to 2 p.m. At that time, I was working near roads by digging a hole. The names of these 4 accused are Tenzin, Raju Lama, Ratan, and Pappu, my lord. This deposition which I have deposed here in this court is stated by me before the police. I have nothing more to say in this regard. Now, cross-examination. In fact, I know the names of 6 accused persons, and they are Tenzin, Suraj Kumar, Raju Lama, Ratan, Pappu, and Kalu. There's no mention of the name of the present appellant. I have never ever seen these 2 accused persons, so I do not know their name. I cannot identify who is Ratan among this accused person standing on the dock. She has identified the rest 5 accused person here in this court. I was working there under a contractor who was constructing culvert. I know the roads where I was working leads towards Shero village and Jungma village. I do not know if this road leads towards some other roads or not, apart from some other village. The said road is pitch road. This said road does not touch the village of the said victim. I cannot say if this said accused person were going to the house of the victim so-and-so or not. I stated before the police that I knew those accused person who were riding on the bike, and if whatever I have stated here in this court is not recorded by the police, then I cannot say why he did not record. I stated before the police that I knew 3 of those 4 accused person. Many vehicles used to ply on that road, but on that day, none were found plying except these 2 bikes till 4 p.m. I'm sure that no vehicle was seen plying till 4 p.m., but I cannot say whether vehicles were plying after 4 p.m. or not. Nothing against me, man. No, page 188, man. I have come to this court to give my statement in connection with so-and-so. I gave my statement to the police in connection with this case. I know one of this accused person standing on the dock. He is Raju Lama. I saw 2 motorbikes going towards the Shero village. I did not see the person riding on the first bike as I was walking down the road. But in the other bike, I saw accused Raju Lama. I know accused Raju Lama and he is present here in this court. I do not know anything of the case apart from the deposition I have given here. I do not know cross-mail. The other accused person is standing on the dock except Raju Lama. I was working there at the said road with Miss Choigi. None other person was present except me and Choigi. This road leads towards Shero village and Jangda. I do not know if it leads towards some other village or not. These bike riders were hauling. I cannot say the type of bike which they were using. No other vehicles, bikes were on flying on that road on that day around 4 p.m. My lord may take the other paper book, my lord. BW8, my lord. I have come to this court as a witness as I received summons from this court. I gave my statement before the police officer at the time of incident. I was reading in class 6. The victim girl in this case was also in my school. 191. I have come to this court as a witness. I have received summons from this court. I gave my statement before the police officer. At the time of the incident, I was reading in class 6. The victim girl in this case was also in my school. Accused person standing on the dock is not known except Papu Bhaiya, Dil Bahadur, as told by Papu Bhaiya himself to this court. On 28 August 2012, victim so-and-so is dead. This accused Papu Bhaiya asked me something and went away on the bike. One more person were there with Papu Bhaiya, whose name I don't know. Papu Bhaiya asked me if the our drummer left or not, for which I told him that she is left. Thereafter, Papu Bhaiya left towards Zumar village. I saw it. So-and-so with 4 other Ani. When I saw it, was with those Ani, and I told her that some boys are looking for her. Then she replied that they must be looking for you. They were talking to each other. Thereafter, I left, and so left for house. Thereafter, she did not see me later. Now, cross-examination. The victim was 1 year senior to me class-wise. I met Papu Bhaiya at around 4 p.m. So I do say that I met victim so-and-so with those Buddhist nun at around 4 p.m. I met them at the place called Yala Gompa area. I know Papu Bhaiya since 1 year before the incident. I don't know many things about Papu Bhaiya, but I saw him on that day. Papu Bhaiya asked me about so-and-so on that day only. He did not ask me before. I don't know why he asked about so-and-so. I have not seen Papu Bhaiya talking with so-and-so at any point of time, and also I have not seen him talking with so-and-so on that day. I saw the bike, but I did not see the color of which Papu Bhaiya came. The bike was a Pulsar bike. The schooling is over by 3:30 p.m. The said victim so-and-so was present in our school that day at 3:30 p.m. with those monks. I did not tell so-and-so that the group of boys were looking for you, but I just said 2 boys are looking for you. No, this is not a fact that I'm telling lie in the court. Nothing against me. PW9, my lord, page 193. I have come to this court because a girl was raped. She was so-and-so. I gave my statement to the police officer in connection with this case. I gave a statement to the police to the effect that I heard so-and-so telling so-and-so that Nepali boys were searching for you at Zumba. Thereafter, I left for my monastery and so-and-so left for her home. By then, we were 4 and they are so-and-so and the victim. I did not hear so-and-so taking any name of a person, but I heard him saying Nepali boys. I have nothing more to say in this regard. The victim so-and-so was my classmate. I was not well acquainted with the victim so-and-so, with whom I used to go home sometime. This victim so-and-so was with us till classes were over. We met so-and-so after school on that day at around 4 to 4:30 p.m. By then, as I said, we're all 5 in numbers, including so-and-so. I do not know the accused person standing on the dock. I have never heard anybody who was looking for so-and-so previous to this incident. I have also not heard and seen any Nepali boys coming to the school and looking for so-and-so. And also, I have not heard so-and-so of having any Nepali friends. I don't know why they were looking for so-and-so, and I don't know if they were really looking for her or not. Well, nothing is there. PW10, my lord. I have come to this court what so-and-so had tell on that day. Pema Banduk told so-and-so that Nepali boys were looking for you. Then so-and-so says that Nepali boys must be looking for you, but not me. And so-and-so were with me when I heard so-and-so saying all these things. I gave my statement to the police in this regard. Thereafter, we all left for Kumba and victim girl left for our village called Zumba. This is all I have to say. Cross, my lord, it is not a fact that I did not hear so-and-so saying all this to us. It must be around 4 to 4:30 when I heard this from so-and-so. The victim so-and-so said to so-and-so that those Nepali boys must be looking for you, but not for her, because she do not have any reason to say that the Nepali boys were looking for her. I don't know if so-and-so had friends. I came to this court for a girl called so-and-so because she was raped. I gave my statement to police personnel in this regard. I heard that so-and-so was telling victim that Nepali boys were looking for you, for which so-and-so replied that they must be looking for you, not for me. With me, the time so-and-so, 1, 2, 3, 4 were present. Thereafter, we left for our Gompa and victim left for her place, and we did not see victim thereafter. I do not know any of this accused person standing on the dock. Even she has nothing to depose against the appellant in this case also. PW12, 199 page. I have come to this court as a witness. I gave my statement to the police officer in this regard. I have come to this court as a witness because victim was raped. I also don't know why she was raped, but so-and-so told victim that Nepali boys are looking for you at Zumba, for which victim said that they must be looking only for you. Thereafter, we went back to our Gompa, so-and-so, At the time when so-and-so told these things to victim, I was present along with so-and-so, 2, 3. Even this has no connection with the appellant in commission of the offense. My lord. Now, PW 13, my lord, page 201. I have come to this court in connection with the rape and murder case of so-and-so. I gave my statement to the police officer in the connection. On the next day of the incident, when I came to the school, I came to learn that victim has been raped and murdered by a person called Siri Pappu and his friends. I also came to know that boy called so-and-so told victim that 2 Nepali guys on different motorcycles were looking for her. Then she told her that why should these Nepali boys look for her? With this said that the Nepali guys must be looking for you, but not me. I also learned that one of them was Pappu. I came to know all these things from my friend, namely so-and-so, so-and-so. This is all what I have learned from others. I do not know the accused person standing on the dock today. The victim, so-and-so, was known to me as she was my classmate. We read together up to class 7, my lord. When there's no any inculpatory statement against the appellant, my lord. Page number 203 is the prosecution witness 14, my lord. May I read one? I have come to this court in connection with the rape case of Miss So-and-so. I know 2 of the accused persons standing on the dock, whose name is Raju Lama, and other person whom I don't know by name, who is standing in the last row. He has told his name as Gaur Bahadur Sonar after he identified by PW11. In the night of 28/8/2012, there was a phone call from Raju Lama at around 11 o'clock. When I picked up the phone, he asked me to meet him. I refused to meet him, so I told him that we will meet on the next day while going to school. But he was insisting and told me that he will not be able to meet me since he is going out for certain works for a long period of time. So I had to accept his proposal. This is how that night I met Raju Lama outside my house at around 11:30 p.m. We talked to each other for 10 to 15 minutes. But meanwhile, my parents and sisters, they came out. On seeing them, Raju Lama got scared. We were sitting inside the car of Raju Lama since it was raining. By then, Raju Lama started the car and hurriedly rushed towards the Tawang with me. While driving hurriedly, the car met an accident by dashing the bridge at Bomdil. We sustained injuries. I was injured at my forehead. Raju Lama got injured on mouth. The other accused person, whom I do not know by name, but whom I identified in this court, was searching in the back seat of the car, and he did not sustain injuries. Since the vehicle could not be started, we started marching towards a village called Jingtan by foot, where we met one Sri Kancha Lama. Thereafter, this man named Kancha Lama dropped us on his own vehicle to Shortcut Junction towards Krimu. This is how we reached the house of the accused Raju Lama, and it was almost dawn. When accused Raju Lama came to my house, he told me that he is coming from a party, as one of his friends had thrown a party for having purchased a new bike. I can't say if Raju Lama was drunk by them or not. I came to know Raju Lama 3-4 months back before the said incident. Accused Raju Lama did not tell me anything about this case in the night when we met. Even in this case also, my lord, there's no any inculpatory statement or deposition against the appellant, my lord. Now, if I may read page number 206, PW 15, my lord. I have received a summons in connection with this case of victim, so I am here in this court today. I gave my statement on to the police officer in connection with this case. On 28/8/2012, I was at India Gate running a shop. On that day, 2 bikes arrived and the rider took 2 bottles of beer from my shop. On those 2 bikes, one Sri Tenzin, Raju Lama and Pappu, and one more person whom I did not know came. After collecting the beers, those boys left around 3:30 p.m. On next day, I could learn that victim was raped and killed. I could also learn that those boys who came to my shop were arrested in connection with this case. I recognize Pappu, Raju Lama and Tenzin as they are standing in the dock today. I have nothing more to say. Even in this case also, the name of the present appellant is nowhere mentioned, my lord. Now, PW 16, page number 208. I have received a summons in connection with this case of victim, so I'm here in this court today. I gave my statement to the police officer in connection with this case. On 28/8/2012, while I was going towards the house of my house, I met 2 motorbikes. They were coming towards Lao. Among those persons who were riding on the motorbike, I could recognize Raju Lama and Pappu. On that date, around 6 p.m., we were told that our drama is missing by the villagers. Next morning, we learned from the father of victim that victim has been killed by someone. The body was found down the road in between India Gate, Sherogomba. I went to the PO and saw the dead body, which was lying in the naked position, and an injury was found on the head. The police personnel were informed and the dead body was sent for postmortem. Those 2 boys whom I have mentioned were arrested in connection with this case. These 2 persons are present today here in this court. They are standing on the dock. My lord, even he deposes against Raju Lama and Papu on the date of the offense, my lord. Now, page number 210, my lord, prosecution witness 17, my lord. 210, my lord. I have received a summon in connection with this case of Dawa Drama, so I'm here in this court today. I gave my statement to the police officer in connection with this case. On the day of the incident, 6 persons came to my restaurant and took beer at around 8 to 9 p.m. I know those persons, namely Raju, Kalu, Pappu, Suraj Kumar, Tanzin, and Sanu. They are present in court here today. My shop is located at Yangla Gompa area. They later left my restaurant on 2 bikes and 1 alto car. Next day, I could learn that victim was raped and murdered and she was thrown down the road. I also could learn that those persons who came to my restaurant and had beer with the arrested in connection with this case. I do not know the other accused person standing on the dock by name and by face. I gave my statement to the police on that day on which these accused persons were arrested. I do not remember the date. I used to open my shop when I came back from my work after 4 p.m. Army personnel used to come every evening in my restaurant. They used to buy and go. Sometimes the army personnel used to come in their vehicle. I know the accused person who are named by me since last 10 to 11 years from the date of the incident. I have not heard that they were involved in other cases except the present one. I know the parents of the accused person. Their parents are staying in the Timor Village since last many years. Now, my lord, PW 18, page 212, my lord.
Yes.
I have received a notice from this court in connection with the case of Dawa Drama, so I'm here in this court. Today, one day while I was going with victim, we met Raju Lama on the way. He stopped his vehicle and asked us if we want to go with him, for which we refused to go with him. We did not call him. We met him 3 months before the said incident. Raju Lama is present here in this court and he's standing on the dock today. This victim was my friend as a classmate. I could learn that Raju Lama and others are arrested in connection with this case. Nothing inculpatory against the appellant, my lord. Now, PW 19 is the doctor, my lord. My report.
Yes.
I have summoned by this court to give my opinion as I am one of the doctor who examined the accused and conducted PM of the victim. Name of the victim whom I've examined was Miss So-and-so. I have conducted the PM. Along with me, there were 2 more doctors who examined the accused and the victim, and they were Dr. So-and-so. This PM report, I have exhibited this PW2, paper exhibit 2A is my signature on it. After conducting the PM, we concluded that cause of the death was because of the head injury. We also concluded that sexual intercourse could not be ruled out. Hence, we sent the sample to obtain report from the forensic expert. We sent the sample just to ascertain the active agent as to confirm that the victim was sexually assaulted. The samples of the accused person and the victim were sent. We concluded that head injury had caused the death. Most importantly, the subdural hemorrhage over left temporoparietal region of the head. Such injury could be caused by a blunt weapon or an object. We concluded that the victim has been sexually assaulted because of the presence of corrugated or torn hymen, which was recent torn. The vagina opening was 5 to 5 cm with foul smelling. The injuries found on her body and found on her private part were antemortem injuries. These antemortem injuries could have been caused between 12 to 24 hours. Bruises were found on the right shin or leg and abrasion on the right knee, joint, anterior aspect. Multiple injuries found on the lower limbs are also mentioned in my report. The 2 ligature marks which I found on the body of the victim are also mentioned in my report. As per our examination, third molar teeth was yet to be erupted, and also the examination of the elbow. Well, basically, this the doctor deposes in respect of the condition of the victim, my lord. Now, as much as my lord, 19 prosecution witnesses were deposed. They have been testified before the learned trial court below. None of the deposition mentions any name about the present appellant. Now, my lord, if I may take my lord to since I won't be pressing much on the first sample, first DNA report, since that has been, the result has been negative. Now, the second recollection of the sample, if I may take my lord.
Yes.
For the time being, the forwarding of the sample has not been enclosed in the paper book, my lord. The main petition, my lord, for a time being, if I may take my lord to page number 121 of the main appeal petition, my lord.
121.
My lord. 121 of the men. This is the recollection of the sample which was forwarded to the laboratory. My lord, top, my lord, confidential through a special messenger. My lord, the date of forwarding is 14 February 2013, my lord. Now, side by side, if my lord may take page number 239 of the paper book, that is the deposition of the expert, my lord.
200.
239, my lord. Now, my lord,
Yes.
her deposition. On 15/9/2012, I received one parcel from director, DFS Assam, in connection with Jung PS case number under section 302, white memo number so and so, my lord. My lord, the expert has testified that she has received the sample on 15/9/2012, whereas as per the forwarding, my lord, as per the forwarding report, my lord, the samples were forwarded in the year 2013, my lord. She has received 1 year back, which is in fact very much contradictory as per the forwarding of the sample, my lord. On 15/9/2012, I have received one parcel from a director, DFS Assam, whereas the recollection and the sample was forwarded on 14 February 2013, my lord.
Is first sample or second sample?
Second sample, my lord.
So this repose about first sample or second sample?
Second sample, my lord. My lord, if I may read.
Are you sure?
Yes, my lord. In the next page, my lord, if my lord may see, 240. My lord, serial number 1.
Yeah.
My lord, if my lord
You
may,
come to page number
20.
120.
120 of the paper book, my lord.
No, it is
Your appeal.
appeal petition.
120. This was also the forwarding, my lord.
Yes.
14.
So it was this come to this memo number.
Please refer to so and so.
Yes.
Recollection of blood sample of 8 accused of the accused person so and so be sent to FSL Guwahati Assam for DNA analysis. As directed, the blood sample of all 8 accused were named
No,
as
come
are given below.
Come to page number 121.
121,
This reference memo number.
my lord. Reference, my lord, your memo number so and so. 7
Dated
February
14
2013.
February 2013.
Yes, my lord. This is
So there
reference.
is a mistake of
They have rightly sent, my lord. They have rightly sent. But the one who has received it, my lord, she has deposed that she has received on 15/9/2012, my lord. And in fact, she is not the person who has received the sample. That is the reason, my lord, I was pressing that the messenger who was entrusted to hand over those samples to the laboratory ought to have been examined before the trial court, so to justify the integrity of the sample. Number 2, my lord, the director, DFS Assam, who has received those samples from the messenger ought to have been examined only to justify the integrity of the sample. Because as per the oath, under oath, the deposition given by the expert, she states that she has received the samples on 15/9/2012, my lord. Whereas the samples were already collected, samples were collected in the year 2013, my lord. How that can be possible, my lord? That is the reason I was doubting the authenticity of this DNA report. Otherwise, my lord, if we go by the deposition, my lord, there's not even a single inculpatory statement made by the prosecution witnesses or the co-accused against me, my lord. Since this whole case is rest on a circumstantial evidence, my lord. My lord, it is well settled, my lord, the circumstances under which a guilt is sought to be drawn must be cogently and firmly established. The circumstances, my lord, if taken cumulatively, my lord, must form a chain so complete that with all human probability, my lord, it should be pointing, the finger should be pointing towards the accused person. Whereas in this case, there's nothing against me, my lord, except this DNA report, and the deposition is also contradictory. And if my lord allows me, I'll just place some authorities only to show the evidentiary value of DNA when there's no other corroborative evidence, my lord.
Whether the same expert has examined the first sample also?
First sample was different expert,
Different.
different expert. And I've made a compilation, my lord, first judgment in respect of the evidentiary value of the DNA, my lord, in absence of any corroborative evidence. If I may take, my lord, to page number 38, my lord. Since there's no any statement pointing fingers towards me at this stage, since they are only relying on the DNA report, which is full of flaws, my lord. Page 38. Para 139.
One?
139 paragraph, my lord. 139, 140, 141, page
Okay.
38, my lord.
Hmm.
Several decisions of this court, in the name of the decisions, my lord, down below, have dealt with the increasing importance of DNA evidence. This court has also emphasized the need for assuring quality control about the samples, as well as the technique of testing in Anil versus so-and-so. Deoxyribonucleic acid, or DNA, is a molecule that encodes the genetic information in all living organisms. DNA genotypes can be obtained from any biological materials such as bone, blood, semen, saliva, hair, skin, etc. Now, for several years, DNA profile has also shown a tremendous impact on forensic investigation. Generally, when DNA profile of a sample found at the scene of a crime matches with DNA profile of the suspect, it can generally be concluded that both samples have the same biological origin. DNA profile is valid and reliable, but variance in a particular result depends on the quality control and quality procedure in the laboratory. 140, my lord. This court, in one of its recent decision, Patturajan versus State of Tamil Nadu, considered the value and weight to be attached to a DNA report. Like all other opinion evidences, the probative value accorded to DNA evidence also varies from case to case, depending on facts and circumstances, and the weight accorded to other evidence on record, whether contrary or corroborative. This is all the more important to remember, given that even though the accuracy of DNA evidence may be increasing with the advancement of science and technology with every passing day, thereby making it more and more reliable, we have not yet reached a juncture where it may be said to be infallible. Thus, it cannot be said in this absence. 141 is important, my lord. This court, therefore, has relied on DNA reports in the past, where the guilt of an accused was sought to be established. My lord, notably, the reliance was to corroborate, my lord. So, in isolation, my lord, solely on the basis of this one DNA report, where there are numbers of contradictions, my lord, cannot be relied upon to base the conviction of the appellant, my lord. Now, my lord, if I may take my second authority, my lord. Our division bench, my lord, this authority in respect of DNA has been passed. I'll just read only past para 13, my lord. Para
Page
13,
number?
page number 3, my lord. Second authority, second judgment, my lord. May I read, my lord?
Yes.
Just a simple single line, man. In Premji by Babubai Kashia Supra, the apex court, referring to the DNA report, held that a positive report can be of great
Page
significance.
number 3 of this,
Second judgment, my lord. Division bench, my lord, 2016, my lord.
second judgment.
My lord. Page number 3, my lord. Third judgment, my lord, sorry. My lord has
Page number 3.
3, my lord. In Premji by Bahubai Kasia Supra, the apex court,
Still saying,
my lord,
if the law is settled by Supreme Court,
my lord,
is there any necessity to go to the
My lord, yeah.
decision of High Court?
my lord, understand. Just only I was referring, since similar matter was taken up and then it has held that, my lord, in isolation solely on the basis of the DNA report, a person cannot be convicted unless and until there is any corroborative
Which
evidence.
paragraph you are referring?
Para 13, my lord.
Okay.
In Premji by Bahubai Kasia Supra, the apex court, referring to the DNA report, held that the positive report can be of great significance where there is a supporting evidence. However, such report cannot be accepted in isolation as a sole piece of evidence to record conviction, my lord.
Okay. Any other point?
My lord, I have few more judgments, my lord, in respect of DNA experts, my lord. Judgment number 4, my lord. Para 32. May I read, my lord?
Yes.
It is true that PW 23. Para 32. May I read? It is true that PW 23, Dr. B.K.
Page
Mohapatra,
number?
para number 32, my lord.
30.
Page 16.
So saying we will resume at 2 o'clock.
My lord,
We have one full court meeting today.
my lord,
We have to join to receive
my lord,
139.
my lord.
Okay.
39, my lord. 32, sorry, man, 32. Let's read this paragraph, my lord. Court judgment, my lord, this one is Rahul versus State of Delhi, Ministry of Home Affairs in another. Para 32. Internal page 16, my lord.
Internal page.
16, 16, my lord.
Okay, it is true.
Yes, my lord. It is true that PW 23, Dr. B.K. Mohapatra, Senior Scientific
okay.
Officer,
Okay.
Biology of CFSL, New Delhi, had stepped into the witness box.
Resume at 2 o'clock.
Incomplete chain of the custody of the sample, as
Mhm.
well as non-testified before the court, my lord. If my lord may, if I may take my lord to para 59, judgment number 2, my lord. Prakash Nissan, State of Maharashtra.
Fifty-four.
59, my lord. Starting from para 59. May I
Okay.
read? As has been hitherto observed, there is no clarity of who took the sample of the appellant. In any event, record reveals that one set of samples taken on so and so were sent for chemical analysis on 16/6/2010, and the second sample taken a month later on 27/2010 is sent the very same day. Why there exists this differing degrees of probability in respect of similar, if the same nature scientific evidence is unexplained. We may observe that the Maharashtra Police Manual available in so and so, when speaking of the same The document also lays emphasis on the chain of custody being maintained. Chain of custody implies that right from the time of taking of the sample to the time it's rolled to in the investigation and process subsequent is complete, each person handling the said piece of evidence must duly be acknowledged in the documentation so as to ensure that the integrity is uncompromised. It is recommended that a document be duly maintained cataloging the custody. A chain of custody, in other words, is a document which should include name or initials of the individuals collecting the evidence, each person or entity subsequently having custody of it, dated the item were collected or transferred, agency and case number, victims or suspect name in the brief description of the item. My lord, in the present case, undoubtedly, my lord, recollection was done and altogether there were 8 accused, my lord. And that recollection has been sent after a period of 5 months. And the person who was entrusted to hand over those samples to the laboratory was never examined, so to justify the integrity of those samples. And my lord, there is no record as to who has received those samples. Now we assume that the director DFS Assam has received the sample since he has handed over to the expert. There is no deposition to that effect that as to from whom he has received those samples, my lord. So that is very vital, my lord.
During the examination of the expert, the FSL,
My lord.
whether you put such question to her.
My lord, so long as it is on the part of the prosecution to bring those on record, my lord. The prosecution, since has not brought those witnesses before the court for examination, we had no opportunity to cross-examine, my lord.
That's all right. Director of FSL is not before the court,
My lord.
but the expert was available.
Well, the expert says she has received the samples in the year 2012, my lord.
Yes.
Whereas the samples was recollected in the year
Whether you put any
2013,
question to her in respect of the integrity of the sample.
my lord. But,
No, you answer my question.
my lord, those questions were not raised to her, my lord. But to my humble understanding, it would be the messenger who would justify that, yes, I have handed over those samples to the laboratory and so Mr. So-and-so has received those samples from me. And the person who received would be the best person to answer, my lord, before the trial court as to in what manner he has received the samples.
So whether you have made any prayer before the trial court to summon the director of the FSL?
My lord, no, my
No.
no, my lord. My lord, to my limited understanding of law, I think, my lord, it is the prosecution who has to bring everything on record to prove the case beyond reasonable doubt.
No.
Thereafter, my
You
lord,
have-
it's
you
a
have
defense,
asserted the point.
my lord,
Then
my lord. Thereafter, my lord, I'll rely on another authority, my lord, if my lord,
Mm.
in respect of in respect of the motive, my lord. Judgment number 6, my lord. Estate of UP versus Rajveer. Judgment number 6.
yes, fair
My lord,
enough.
if my take to para 8, my lord. May I read, my lord?
Yes.
We have carefully considered the submission made by the Lani Council for the parties. It is the case of the prosecution that the other 2 accused, namely so-and-so, had motive against the disease and the respondent had no motive whatsoever against the disease. All the 3 accused were friendly among them. It is true that Rule 1 to 3 have supported the prosecution case that all the 3 accused went to the house of the disease on the date of the incident and the respondent called the disease to attend the patient immediately. PW 1 to 3 also stated that all the 3 accused assaulted this, but the evidence PW 1 to 3 is specific and consistent as to the assault by the accused Chandra on the deceased with knife. As to the assault by the respondent, the statement of the witness are general and vague. No specific overt act is attributed to the respondent. It may also be mentioned here that there was no recovery of knife from the respondent. There was no recovery of blood-stained clothes from the accused Chandra. It is possible that on the accused Chandra and Chote asking the respondent to accompany them to the house of the deceased to show a patient, or the respondent himself might have taken a patient also for examination by the doctor. Mere presence of respondent on the spot when the incident took place was not sufficient to hold that the respondent had intention to kill the disease. Particularly so when the respondent had no motive whatsoever. PW1, the brother of the deceased himself, has stated that the respondent had no ill will or motive against the disease. It is under these circumstances, the motive aspect assumed importance. My lord, this is important. There is no dispute as to the legal position that in absence of motive or the alleged motive having not been established, an accused cannot be convicted if the prosecution is successful in establishing the crime said to have been committed by an accused by other evidences, my lord. In this case, my lord, I don't know the victim, my lord. I'm nowhere connected with the family or the victim, my lord. There's no more at all whatsoever, my lord, has been established by the prosecution. So to point fingers towards me, my lord. Come to a conclusion that the accused had murdered and burned Shashi as alleged. It is settled position of law that circumstances, however strong, cannot take place. The proof and the accused have to be proved by prosecution beyond reasonable doubt. At this juncture, let us regurgitate the golden principles laid down by the court in Sharad so and so versus State of Maharashtra. This court, while drawing the distinction between must be and may be, observed as under in para 153. A close analysis of this decision would show that the following condition must be fulfilled before a case against an accused can be said to be fully established. The circumstances from which the conclusion of guilt is be drawn should be fully established. It may be noted here that this court indicated that the circumstances concerned must or should and not may be established. There is not only a grammatical but a legal distinction between may be proved and must be or should be proved, as was held by this court in Shivaji versus so and so, where the observation were made. Certainly, it is the primary principle that the accused must be and not merely may be guilty before a court can convict. The mental distance between may be and must be is long and divides vague conjectures from sure conclusions. The facts so established should be consistent only with the hypothesis of the guilt of the accused. That is to say, they should not be explainable on any other hypothesis except that the accused is guilty. The circumstances should be of conclusive nature and tendency. They should exclude every possible hypothesis except the one to be proved. There must be a chain of evidence so complete as not to leave any reasonable ground for the conclusion consistent with the innocence of the accused, and must show that in all human probability, the act must have been done by the accused. In this case, my lord, there's no averment or there's no even a single inculpatory statement which has been made against me by the prosecution witnesses, pointing fingers towards me for the commission of the offense, my lord. Everyone is silent, my lord, except on the DNA report, wherein altogether there were 8 accused, my lord. There is every possibility that, my lord, there could be a possibility of manipulation or contamination, my lord. That is the reason, my lord, and solely on the basis of the DNA, my lord, I ought not to have been convicted, my lord. I'll just show the last observation of the London trial court below in the judgment, my lord.
First, you show us how you have dealt with in your 313 statement
My lord.
regarding the only incriminating circumstance
There's
which the prosecution side has established against you.
There's not even a single incriminating question which has been put to me, my lord.
So regarding this
My lord.
DNA sample,
My lord.
certain statement is at page number
157.
7.
157, no? First question, my lord. Shri Ngawang Muru, father of late so and so, deposed that on 28/8/2012 during evening, he found his deceased daughter missing from home. With the help of the villagers and family member conducted search operation until midnight, but they could not trace her out. What do you have to say on this? I don't know, my lord, since he has no idea. PW1 deposed that next early in the morning, he found the deceased lying dead in half nude in jungle nearby Gompa. He informed his wife and police. He subsequently lodged an FIR at Jang police station. Do you want to say anything on this statement? I don't know. Kendan Singh has recognized you, Raju Lama, Dil Bahadur Elias and Tenzin as accused during deposing his evidence before this court. What do you have to say on this? I don't know. PW2 deposed that on 28/8/2012, he along with other villagers joined in the search operation for missing girl let so and so till midnight in and around the place where she was seen at about so and so. He further stated that in the meantime, at about 9:30, Raju Lama moving here and there in suspicious manner. Do you want to explain to this statement? I have no comments. PW2 deposed that by midnight, they came home and next day morning, so and so traced dead body of the deceased lying facing down the ground in naked position. Do you have anything to say on the statement? I don't know. Further deposed that after recovering the dead body of the deceased, he and other villagers on suspicion went straight to Raju Lama's house, seeking reason as to why he moving in suspicious way previous night nearby the place that has been located. Do you have anything to explain on this statement? Later on, I came to know that some villagers had gone to Raju Lama's house on 29/8/2012. PW2 revealed that on the day of missing of the deceased, Raju Lama, so and so, Bahadur Tamang, Suresh Gurung, Tenzin consuming liquors at Bozing at India Gate and later evening at Yalagompa area. Do you want to evidence in defense? Answer. I, Raju Lama, Dil Bahadur, Tamang, Suresh Gurung and Tenzin had consumed liquor at Craft Center before reaching India Gate from 0 point. Well, may kindly say. Prosecution 3, Sri Phunchok deposed that on receipt of information regarding missing of the deceased, he along with other co-accused, co-villagers went searching her nearby labor camp at India Gate, which is in the periphery of the house deceased, and so Raju Lama looking for his Sri Tenzin and others in a suspicious way. Do you have anything to say? I don't know. PW3 stated that he searched him moved towards Kumbhabra, where the monk last saw the deceased on the day of her disappearance. He further stated that in the meantime, Raju Lama came back still looking his friends during odd hours. Thereafter, Miss So-and-so dialed at Tenzin mobile's number and confirmed that he at the time was available in the residence of Sri Srintashi, local MLA. What do you have to say on this revelation about events occurring on the particular night? I, Tenzin and Sagar Sona left the drink party at Craft Center. I do not remember the time. PW3 further deposed that after recovering the dead body of deceased, he and other villagers on suspicion went straight to Raju Lama's house seeking reason as to why you had to move to and from previous night near the place that has been located. He further stated that on their query, Raji Lama revealed that on the day of missing deceased, Sri Tenzin, Dil Bahadur, Tamang, Elias Papu, and some other friends were with imposing at India Gate, later evening at Yalagompa till midnight. However, Tenzin suddenly disappeared from the group. Do you have anything to explain on this? I don't know. PW3 stated that on the day of missing of the deceased, you, Tenzin, and other friends celebrated consuming alcohol at the success, Tenzin buying a new motorbike till 9:30. What do you have to say on this? This is true. However, I don't remember the time. PW5, Mrs. Renchin Rama deposed that on the day of missing of the deceased, you was already at her home and 6 p.m. You left her home, did not return for night. Do you have anything to explain? This is true. Striding towards the house of the deceased victim. Do you want to give explanation on a statement? I was not amongst them. Further deposed that on the date of alleged incident till 4 p.m., no motor vehicle plied on the road except your motorbike. What do you have to? I cannot say. Miss So-and-so deposed that on the date of alleged incident, she saw you and friends riding on 2 motorbikes towards Sharo. What is Raju Lama? What do you have to say? I was not amongst them. So-and-so deposed that on 28/8/12 at about 4 p.m., being inquired by Papu and his friends about the disease, he told him that the victim has left the school. Thereafter, you went towards Dungura village. Later on, PW8 saw the disease with 4 nuns at Yalagompa area. He told her that Papu and friends were looking for her and she declined to approve the same. Do you want to explain on this? I don't know. PW8, question number 21, stated that the disease was in the school till 3:30 with your nuns, with 4 nuns, and after school hours, the disease at Yalagompa at 4 p.m. with same nuns. What do you have to say on this? I don't know. Question number 22, Ms. Choyang deposed that on the day of occurrence of the present case, she heard from so-and-so that some neighbor
Petition dismiss. Liberty is there. Transfer order state. June. Mr. T. Partin, learned counsel for the petitioner with consent from the other side, was for listing the matter on 17th of June. Okay, fair. No, that direction cannot be issued. Yeah.
Maybe, my lord, item number 16, my lord, is a quarter matter. So may I please, my lord, if your lordship enough, can it be taken tomorrow, my lord?
Tomorrow. Okay. On the appeal being made by Mr. Tison, learned amicus curiae. Raises list the matter tomorrow.
Oblige.
Lordship, I beg to mention item number 14 and 15, Lordship. In this
When?
item, Lordship, we need to file our counter affidavit, Lordship. For that, we need 2 weeks time. Lordship.
Okay. Ms. P. Songeta, learned counsel for the respondent authorities. With consent from the, you inform the petitioner?
Yes,
With consent from the other side, first for listing the matter. When? After?
2 weeks, Lordship.
After 2 weeks. Fair
Okay.
allowed.
Okay.
Item number is wrongly listed as a motion item, notice already issued, my lord.
Okay.
The service report, we have taken a
Await.
step. Yes, my lord. We need to
Okay.
file, we have taken a step through Dusty also. We'll file the affidavit in due course of time, my lord.
After?
Within 2 weeks, we'll file.
Okay.
Then-
Heard Mr. T. Tagum, learned counsel for the petitioner. Mr. Tagum submits that this repetition is being listed today in the motion column, but already notice has been issued by this court by the order dated 15/5/2025. And he has effected service upon the respondents by Dastimut, and he will be filing his affidavit within 2 weeks.
My lord,
2 weeks.
within 2 weeks, we'll file. Let's
Within
list
2 weeks.
after.
Within 2 weeks.
Within-
Mr. G. Tarak, learned counsel for the respondent number. 1 to 4. 1 to 4.
Hmm.
1 to 5.
Yes,
1
my
to
lord.
5, yes, 1 to 5 present.
1 to
In respect of Tagam, it is step 4, 6, 7, 8, 9, 10, 11. You have for RWD also.
Yes, RWD, standing counsel.
So this executive engineer is in his personal capacity as 11,
My lord, it is the
chief engineer.
chief engineer, personal, my lord.
Yes.
Because chief engineer personal capacity also there,
Okay, okay.
because
Okay.
the work has been awarded to the her
Okay.
own, his own wife.
Okay, next.
Met your last.
Hmm.
The matter actually relates to non-payment of contractor's bill. Earlier, my lord, when the amount was not being paid, we approached this honorable court and this honorable court passed an order which your lordship will find at page 38. There is already an order.
Then why this rate petition?
My lord, there is a reason after this direction for payment was there.
Hmm.
The government initially filed a review petition, didn't file any appeal. In the review petition, there is no stay. So during the pendency of the review petition, the government decided to make the payment and comply with the direction.
Hmm.
And accordingly, demand drafts were prepared
Hmm.
for in 2, 3, 4, 5 demand drafts.
Hmm.
Out of that, one demand draft has been released. And so far as the government is concerned, my lord, there is absolutely no dispute. Government has got no objection. The government has given the sanction, the approval, demand draft has been prepared from the treasury.
Hmm.
Now the director somehow is not releasing the remaining amount of draft, my lord. Lordship, I have
The
mentioned here,
draft has already been issued to you.
issued, my lord, lordship will kindly see,
Then?
out of 5 drafts,
That's all right.
what,
All the drafts are given to you.
no. Drafts are to be given through the directorate office.
Hmm.
So one draft has been given to me. Remaining drafts are withheld. My lord,
Why?
That's why, my lord, my learned film will say. I have mentioned para 19, Lordship will kindly see to the knowledge of the petitioner, that may be the reason, my lord.
Mr. Zamo? Why the other drafts are being withheld?
Your Lordship, petitioner has mentioned that review petition, my lord. We are actually waiting for the outcome of the review petition, my lord.
Then how can you make payment of the one draft?
50% they have paid. My lord, possibly my learned friend.
No,
will not-
Mr. Zamo, it is serious matter.
Yes.
My lord,
You are violating the court's order.
my lord, I'm already in contempt. I can understand it, my lord, yes.
So you do one thing, we list the matter, tomorrow you obtain instruction.
No, my-
Otherwise, we will direct the, who retained it?
The director may respond number 2.
Director. He shall remain present in the
No,
court
no,
personally.
my lord, okay, order may be passed, my lord. Order may be passed then.
My lord,
No need to.
No,
director.
why the
No, my lord,
drafts
my
are
lord,
being retained by him?
I am under instruction, my lord. Only that is the sole ground, my lord. And only that is the sole ground that he was apprehending that the review petition is there. For that manner,
No,
for that, he is-
no, the petitioner will give an undertaking then.
okay, my lord, okay. Let him give.
My lord, Lordship will kindly have a
If the outcome of the review petition become unfavorable to you,
My lord.
then you will return the amount.
My lord, that would have been a very reasonable submission
Hmm.
and a reasonable order in my humble submission from some court, had no amount been paid. Here is the case, when Lordship may kindly have a look at page 46. Government has done everything. I have got no quarrel with the government.
Hmm.
It is the director for illegal gains. I have to use the expression, my lord. For illegal gains, he is withholding the draft and nothing else. And Lordship may kindly have a look at page 46. One direction is necessary from your Lordship that it should be released immediately and nothing else is required. Lordship may dispose of the petition, my lord. Page 46, Lordship may kindly see. 21st of March 2025 is after the my lord, the government passed the order.
Hmm.
Lordship has got my page 46.
Mhm.
The governor of Arunachal Pradesh is hereby pleased to accord administrative approval and expenditure sanction to an amount of not exceeding so and so only for payment of pending HTH bills of the following farms in compliance with the Honorable High Court Division Bench Nahalagun judgment that is so and so passed in so and so, subject to actual availability of fund during the current financial year so and so. The expenditure is restricted to so and so. Then, my lord, Lordship will kindly see the last page, page 48
Hmm.
of this letter itself. These issues with the finance concurrence by note number so and so dated 20th of March 2025.
Hmm.
Then, my lord, next page, Lordship will kindly see page 52, the first, how they have, with a forwarding letter, how they have released the first draft. Page 52, my lord.
Hmm.
This is the finance and accounts officer. He is response number 3.
Hmm.
I am to forward here with a demand draft number so and so dated so and so amounting to so and so. Only being payment of pending HTS bills in compliance with the Honorable High Court Division Bench order, judgment and order so and so passed into it. You are requested to submit money receipt only. So for 50 crore, they have issued this demand draft with the forwarding. Draft also I have annexed, my lord. Remaining drafts are ready. Page number 54 to
Hmm.
57. I have got a photocopy of the demand drafts, but they are not releasing. And I have mentioned reason is nothing, my lord, for illegal gains. Lordship will simply direct that forthwith releases, otherwise there will be a personal compliance, my lord. Nothing, and nothing will remain in the petition, my lord.
Yes.
My lord,
Otherwise, it's a clear case of
this
contempt.
illegal gain and all that, that doesn't exist actually. I humbly submit, honestly submit, my lord. Actually, the ground is only the review petition, my lord. Since your lordship,
No, that
My-
cannot be the ground. If
My
the
lord.
government has taken a decision to make payment,
my lord,
who are you?
Sanctioned the full amount.
your lordship.
Then
order
how
may be
can you
passed
make
or-
payment of the first draft?
Yes, my lord, we have paid, my
Hmm?
lord. And order may be issued, my lord, with an undertaking, my lord. We will do that.
That will be going beyond the earlier order passed by the Assembly Court. They have already sanctioned it. It is my money, my lord. Contractor's bill. And 50%, they more than 50% they have released. 50 crore is more than 50%.
No, you can furnish on undertaking subject to outcome of this review petition.
Undertakings.
Hmm.
For the first payment,
No, that's all right.
demand of no undertaking
No,
was
no,
taken
no,
by.
that's all right, that's all right.
Right.
But since the review petition is pending
My lord.
and yet to be decided,
My lord.
let one undertaking be given.
I can, if a lordship directs, we will have to, but otherwise, for the first payment, from the side
No,
of the government.
otherwise there would have been no such direction, but
My-
since the review petition is pending.
My lord, I understand what your lordship is indicating. If they do not release any amount, then this direction is all right. Here, so far as the government is concerned, as per number 1 is concerned, government has got nothing more to do. Undertaking I have to give to the government. Government doesn't want any undertaking because they have released. From their part, they have got nothing to do.
Okay.
Officers cannot do it, my lord, take the undertaking, my lord.
Okay. Pardon?
Officers, my lord.
Hmm.
And why? What? Yes. ma'am.
Mr.
Simple
Zamo,
direction to release the draft.
uh,
my lord, that will-
Mr. Zamo,
My lord.
within 1 week from the date of receipt of certified copy of the order, you have to make payment. No undertaking.
My lord.
My lord.
My lord,
If-
but illegal gain and illegal gain may not be reflected, my lord. There is nothing HS, my lord.
All right.
Okay.
Oblige.
Oblige, my lord.
Yes, next step.
We are on a slippery pitch, my
With your
lord.
lordship, leave my lords. Notes. Notes, am I audible, my lords?
Yes, Mr. Pathak.
My lord.
My lord, before Mr. Pathak starts, my lord,
But while addressing the issue relating to power of attorney, my lord, I had already
My lords,
highlighted about the
am I-
registration aspect.
my
The
lords, am I audible, my
non-requirement of
lords?
registry, the non-requirement of any statutory requirement of witnessing a power of attorney.
Good, Dora is
And
आपको लिखे थे।
presumptions about power of attorney that I had highlighted, my lord. One aspect that slipped, my lord, yesterday is that one of the allegation or the contention that was raised, my lord, is that there is no schedule, my lord, in the power of attorney. Now, my answer to that, my lord, is page 257, my lord, would see this is the award. Now, Arunachal is, my lord, a non-cadastral land. So demarcated boundaries of any individual is not there. So if your lordship looks at the award also, even in the award, my lord, the outer boundary of the land is there, my lord. In the handing over, taking over of land that took place subsequently.
You take,
But then individual boundaries are nowhere defined, my lord, in the award also,
no, it may not be there,
my lord.
but is there any schedule in the
No,
power
there-
of attorney?
no, my lord.
No.
There's no, we could not do it, my lord, because as it is a non-cadastral area, my lord, the individual locations, my lord, were nowhere demarcated in any map or any document, my lord. Even therefore, I am pointing out to the award also. Even the award also does not say that this land is this land is this land is this. Award only says about the total area of land, 537 acres. And it is said that this is the land that is acquired for the Indian Army for establishment of crop ammunition point. So we also mentioned 537 acre that has been acquired for Indian Army at Bam Village for crop ammunition point. So that is basically the location of the land.
And that identity of that particular land is not disputed, my, that land is there. We are otherwise, my lord, named in the award. And award also does not give any detailed description, my lord, about the individual schedule of
No,
land, my
no,
lord.
whatever description is there, you could have mentioned in the power of attorney.
The award, my lord, does not give description, my lord. That is the difficulty, my lord. We have mentioned that only 537 award says it's a award in respect of 537 acres of land at Balm Village, my lord. This is what the award says, my lord. So we also say, my lord, this is the 537 acres of land at Balm Village, Leparada district. Is 259, lordship would see. And there is no plot number survey also that award indicates, in fact, since there is no plot number or survey, my lord, it is said to be nil. Only it says, my lord, district village, Balm Village, area 537 acres, plot, survey, nil. So that difficulty, my lord, is there in Arunachal, being a non-cadastral area. In other places, of course, the identity of land is clear from the land patta itself. The boundary restrictions are there. The revenue map is also there. And everything is clear as to which land is. So here it is a difficulty that is there, and that difficulty is there in the award also, my lord. So none of the documents anywhere, even the deputy commissioner's document also describe individual plots of the landowners. Collectively, only 537 acres at Balm Village, Leparada district is the only schedule that is coming out, my lord. That has been mentioned, my lord, though not separately as a schedule. At the very opening recitation of the power of attorney, we have recited that this is relating to this 537 acres of land, which is
Where
in
it is mentioned?
It is, my lord, in the power of attorney itself. Page 213, my lord. We, the landowners of Balm Village under Basar Circle, Leparada district, Arunachal Pradesh, for army land acquisition of 537 acres of private land for operation and necessity of establishment of crop ammunition point. So this is what is also mentioned in the award, my lord, 537 acres crop ammunition point for army at Balm Village, Leparada. So there is no dispute as to the identity of, and this is not a reference, my lord, regarding apportionment. In some cases, my lord, as to who is entitled to receive, my lord, in apportionment dispute, my lord, yes, whose boundary is where and whose area is which much. These things become vital. But then in this case, my lord, the total area is basically what we are concerned about, and the individual share in area is also demarcated in the award. But then the individual boundaries are nowhere there, my lord, except for the collective boundary saying that this is the location of the land. So that is how we have described, my lord, this, and beyond that I cannot add anything, my lord, because this is what is there on record only. Now, another aspect.
On what basis the deputy commissioner has decided the compensation amount which the landowners are entitled to?
My lord, he had used a notification. Initially, my lord, there was a government valuation of land in 2012, it's 12/5/2012. That was the initial estimate from which, my lord, the land value was determined.
Yes.
Then, my lord, in 2022, the government came out with a fresh notification also. So therefore, he used that 2020 notification ultimately, from which, my lord, this rate of 150 is taken. And as far as rate is concerned, we are saying that in 2012 also it was 150. How come in 2022 also it is
That's all right.
150?
On that point you have argued yesterday.
I'm not arguing, my lord. I just indicated that this was the reason basically what drove us to the reference, my lord. Because there was no escalation given, my lord. On what was the price in 2010-12? In 2023-24, no escalation was given. That was the reason that was driving us to reference, my lord. Because as I said, if we got that money 150 in 2012, maybe it was sufficient. But then it isn't because of so many factors of escalation on commodities and price and including that.
Other aspect, my lord, is that judgment of
court that has an operation of law, my lord. Our High Court or any other High Court or for that matter of fact, the Allahabad High Court has not formulated any rules on the basis of that, my lord. So had this been a judgment, my lord, under 142, it could have been, my lord, probably declared as the law and everything had to be followed squarely as per the provisions of that particular judgment.
But even then, it has some persuasive value.
It would have, it would have. I have not denied it. I have not denied it, my lord. That is one aspect. And the question is, my lord, the main question that came in from that particular judgment is the interest of the power of attorney holder. Now, whether a power of attorney holder can have interest in the property of the principal is actually how we have to look into it. Say, for example, I am the principal. I have given a power of attorney to X. Whether the attorney holder has any interest over my property is what is understood, or what is the meaning of this word interest there, my lord. Here is a case, my lord, where the power of attorney holder is only representing them for a litigation, my lord. He has not said that I have any claim over whatever entitlement of the other persons would be. The other persons might be found to be entitled to something. I have no claim over that. So therefore, I am not mixing up my interest with their interest, and my interest survives in the case, my lord, because I am also one of the landowners. So that being the fact, my lord, whether my power of attorney can be therefore segregated by saying that, or nullified by saying that I have an interest in the property. I take a very common example, my lord. Say 4 landowners, my lord, go for a development agreement of a particular land. Now, 4 of them are landowners, my lord. They give power of attorney to one person to develop the particular land. He represents him in all litigations. Now, the interest of these 3 persons, my lord, I also, being a landowner, become a party to any litigation that will happen over that particular land. So, there is no legal bar in a party who is having a portion of land in that particular area, who is also aggrieved to represent the others. Only bar would come, my lord, when he is saying that I am claiming interest. Therefore, I was pointing out that this power of attorney does not entitle him to receive anything, my lord. If any enhancement comes, he is not entitled to receive anything. It will go to the individual beneficiaries, my lord. So therefore, his interest is not mixed up with the interest of the other persons, but then it is a common interest that they are pursuing, my lord. And therefore, he is entitled to pursue the matter, because otherwise, my lord, if this proposition is laid down that in a joint ownership property, one particular person cannot be given a power of attorney holder, then in so many cases would suffer, my lord, because there are so many cases where there are joint ownerships. One person represents the parties. He is also a owner. And if he is prevented from appearing on behalf of the others by saying that you are also having a portion of land, therefore you cannot become a power of attorney holder, there is no such restriction I find in the Power of Attorney Act. Anybody can be a principal, anybody can be an agent. Provided, my lord, the terms and conditions of the agency that are agreed between the parties is maintained. Then, my lord, another thing, my lord, has to yesterday, my lord, I had read 101 of the Evidence Act.
101 of?
The Indian Evidence Act. Now it is, I think, 100 it has become 104 now in 2023. I'll be referring to 23 only. And in this regard, my lord, I had submitted, I think, that this case.
No, on, yesterday you have filed one, you have submitted one, ruling of Supreme Court.
My lord. Anil Rishi and Gurbax Singh. my
Yes,
lord.
yes.
Anil Rishi, I think my lordship has also referred to in many judgments
Yes,
I
yes.
could see. Because that lays down the foundation as to who will lead evidence and on whom the burden would lie. I was therefore indicating that there was no evidence from the respondent side, because in Anil Rishi, there is this clear line, my lord, which says that pleadings is not evidence. Once you plead, you have to then also bring your case on evidence. In the evidence, as I read out, my lord, there was no evidence. And now whether all of a sudden, therefore, now in the appeal, can we be, or the trial just be blamed, or we be blamed for not leading evidence, my lord? That was the issue I raised, my lord. And more specifically, my lord, if we come down to again, section 112, I think this makes it even more clear.
Yes.
Burden of proof as to relationship in cases of partners, landlords, and tenants, principal and agent. Principal and agent, my lord, yes. In a power of attorney, there is a principal, there is an agent. When the question is whether persons are partners, landlords, and tenants, or principals and agent, here, my lord, they are saying that this principal agency as a relationship is non-existent, and there was no principal. Agent himself has acted as the principal and created this power of attorney. Then it says that when the question is whether persons are partners, landlords, and tenants, or principal and agent, and it has been shown that they have been acting as such, the burden of proving that they do not stand or have ceased to stand to each other in those relationships respectively is on the person who affirms it. So if a party says that your agency is no longer subsisting, or it is no longer bona fide, or it did not exist at all, it is for him to bring the proof. That again, of course, my lord, we have to read with section 85, now 84, that there is an initial presumption in favor of the power of attorney, which has to be rebutted, my lord. For rebuttal, evidence is required, my lord. And since there was no evidence, my lord, I believe the trial court had proceeded correctly, my lord. And in fact, at this stage also, therefore, I find that there is no application in the appeal also till now, my lord, that additional evidence is sought to be adduced, or the trial court did not afford appropriate opportunity to the parties to lead their evidence, or an application seeking to lead evidence was rejected, my lord. Nothing of this sort had happened. They had never during the trial complained also of the fact that they were, like my lord, prevented from adducing any evidence. Because why I'm saying, my lord, that the power of attorney is again, they are raising issues relating to discrepancy of signature. Apart from the debt issue, my lord, that we have filed a separate IA, lordship would look into it differently and from a different angle. Other than that, they say that there are discrepancies in signatures. Now, signature comparison can to some extent be done, my lord, by the court under section 73 itself. But then if somebody wants to disprove or prove that particular signature, my lord, he could have actually filed an application under section 45 for leading evidence of expert. There was no such application also. So how can we say that the trial judge was wrong, my lord? He came to a finding based on the materials that are placed before him, my lord. It's a different thing that a lot of other things could have been also placed before him. But since it was not there upon, whatever was on record had to be, my lord, looked into, and accordingly on those premises, my lord, it has been decided. So the trial judge is never wrong in this aspects, as I find, my lord. Because the limited point, particularly as I had read out from the written statement, the first emphasis in the argument was about non-registration of the non-registration of the power of attorney. And secondly, discrepancy in signature. Discrepancy in signature, there was no evidence left. And as far as, my lord, the non-registration, the trial court came to a finding that it is not a registrable document, compulsorily registrable document under section 17 of the Registration Act. So therefore, registration is not mandatory, and since there is a presumption in favor of the power of attorney which has not been rebutted, I hold it to be correct and I proceed to decide the other issues. This is how the trial court had gone, my lord. Now, one more aspect, my lord, I had yesterday pointed out. I had pointed out, my lord, that as far as the power of attorney is concerned, since it is a contract of agency, agency can be ratified at any point of time. There is a specific provision in law that entitles such ratification. Even if at that point of time there was no clarity as to whether the agency was created, subsequently the principal, it is only the principal who can come and say, the principal can come and ratify. So in that perspective, in fact, the application of Bomeba, whose husband had died, but she had signed, but then her name was wrongly typed as the husband's name remained in the papers, though she had signed. She can now, even though her name was not correctly reflected, she can ratify the fact that the agency existed, my lord. And to that extent, my lord, I would place one judgment, my lord. Would look at 2014 4 SCC 704.
2014.
4 SCC 704. Hello, this is also a case where power of attorney was not placed before the court. Now, power of attorney is required, my lord, for the purpose, as I say in this case, for the purpose of signing the pleadings, my lord. Now, signing and non-signing of a pleading, my lord, remains a formal effect in a suit. If the parties do not sign properly, the suit normally does not fail. Because any defect in filing or error in filing, my lord, it remains always a curable defect. So that is what, my lord, has been highlighted here.
So which is the relevant paragraph here?
Para 6, my lord. Having heard the counsels for the party and after perusing the materials on record, we find that admittedly authorization of the Board of Directors of the Appellant Federation was not placed before the courts below. But we may notice that specific averment was made by the appellant before the magistrate that the said power of attorney has been filed in a connected case, which has neither been denied or disputed. In any case, in our opinion, courts below were, if the courts below are not satisfied, an opportunity ought to have been granted to the Appellant Federation to place the document containing authorization of records and prove the same in accordance with law. This is because procedural defects and irregularities which are curable should not be allowed to defect substantive rights. Here, my lord, the right to reference is the substantive right, or to cause injustice. Procedure is a handsmaid of justice, which should not be made a tool to deny justice or to perpetuate injustice by oppressive or punitive use. My lord, a similar view is taken again in, my lord, 2006 1 SCC case 75. Here is a case, my lord, where the Wakalarnama was not filed. Wakalarnama is also a power of attorney, my lord, in a way. It empowers a lawyer to appear and represent and plead and do everything on behalf of the parties. And this was found, my lord, at the stage of appeal again. So it was said that even in a stage of appeal, my lord, this can be cured. Para 11 and para 16, my lord. para 15 also, my lord. Para 11, 15 and 16. The principle that remains, my lord, is that procedure should be a handsmaid of justice. If parties, if there is any doubt as to appearance, non-appearance and description of parties, my lord, it can be cured at any point of time. So that provision, my lord, is there clearly in Order 1, Rule 10-2 also, which is also the provision that Bomevan had invoked in her petition. So if we read that with the powers of appellate court in 107 of the CPC, even the appeal court enjoys this power under section Order 1, Rule 10B, which says that, my lord, I just read out a verifiable. Order 1, Rule 10, suit in the name of wrong plaintiff. Where a suit has been instituted in the name of a wrong person, my lord.
Order?
Order 1, Rule 10, my lord. Where a suit has been instituted in name of a wrong person as plaintiff, or where it is doubtful whether it has been instituted in the name of the right plaintiff. The court at any stage of the suit, if satisfied that the suit had been instituted through bona fide mistake, and that it is necessary for determination of the real matter in dispute, so to do, order any other person to be substituted or added as plaintiff upon such terms as the court may think just. So here is a case, my lord, we are saying that error had crept in, not in the signing has been done by the proper person, but then the description of the name of that person, instead of saying as her being the legal heir of so and so, the name of the deceased person remained. And she had signed with the bona fide impression because she is the successor. There's no issue as to she not being the successor of that particular person. Here, one difficulty that lordship would come probably with is that now this fact was not ever, my lord, brought to the light of the trial court. Only in the stage of appeal, my lord, they have filed these two documents, a death certificate and a succession certificate, which we had earlier submitted to the Deputy Commission. Now, these two documents, my lord, are yet to be formally part of the, though filed with the appeal, it cannot automatically be read as a part of the appeal unless and until an application under Order 41, Rule 27 is filed for bringing these two on record. They have filed, there is a IA, my lord, 257 of 2024. They have filed an IA for additional document in respect of, my lord, certain notifications of the government as far as multiplication factor is concerned. But then for this aspect to bring these two documents on record, there is no application till now. Because these are issues that lordship have to touch upon, my lord. So unless and until through a proper procedure of law, these are brought on record. Unlike a writ petition, my lord, it might be difficult. In writ petition, a affidavit is sufficient, my lord. But then here, my lord, some procedures are to be followed to bring them or bring those documents on record. That lacuna, my lord, remains. Because in their appeal also, as I had pointed out, they had named that particular person as a respondent.
Already you have submitted that the procedures are handmade of justice.
My lord.
But when the document is placed before the court,
My lord.
then can the court ignore it only because the procedure of filing those documents have not been followed by the appellant?
No, I'm not saying that it will be ignored. In fact, I also want to bring those on record, my lord, because that is why by filing this IA, I am trying to, because they have not brought it on record. By filing this IA, my lord, I am trying to bring this on record. Lordship would definitely look and have a consideration on that. I am not on that. So they ought to have, but then since they have not, I have filed a IA, my lord. Now, if through that IA, my lord, it will come on record. My lord. Then, my lord, 1972 SCC, 386, my lord. This is a old judgment, my lord, but then I find this to be the only authority, my lord, on this particular subject, authored by Justice Hidayatullah and Justice, I think it's authored by Justice Hidayatullah, the three judgments of the apex court, my lord. My lord, here was the case, my lord, where registration was initially done with a power of attorney which is not valid. Then, subsequently, he filed a second power of attorney, which the court found to be valid. And therefore, it ratified the entire transaction that took place earlier, my lord. Even with the invalid power of attorney. This is what has been discussed, my lord. Para 8. I'll read this, my lord, because some very important aspects of law are touched upon, my lord, here. The short question in this case is whether Mr. Chawla possesses such a power of attorney for executing the document and for presentation of it for registration. Here he, my lord, he had gone for a registration of a sale. As I was pointing out, section 33 requires that power of attorney to be presented in a particular manner so as to enable the attorney holder to validly carry out the registration. Now, if we take into account the very first power of attorney which was executed in his favor on 30 May 1963, we would be forced to say that it did not comply with the requirements of law and it was ineffective to clothe Mr. Chawla with the authority to execute the sale deed or to present it for registration. That power of attorney was not authenticated as required by section 33 of the Registration Act, and which in case of an Indian residing abroad requires that documents should be authenticated by a notary public. The document only bore the signature of a witness without anything to show that he was a notary public. In any event, there was no authentication by the notary public if he was one in the manner in which the law would consider adequate. The second power of attorney, however, shows that it was executed before a proper notary who complied with the laws of California and authenticated the document as required by that law. We are satisfied that the power of attorney is also duly authenticated in accordance with law. The only complaint is that notary public did not say that his endorsement that Mr. Chawla had been identified to his satisfaction, but it flows from the fact that he had endorsed the document, endorsed on the document that it had been subscribed and sworn before him. And this line is also important because, my lord, they are also saying that like the notary has not stated, my lord, he has been identified to his satisfaction. But what the notary does is basically he only subscribes to the fact that the document is sworn. Therefore, my lord, it goes on. It says that there is a presumption of regularity of official acts, and we are satisfied that he must have satisfied himself in the discharge of his duties that the person who is executing it was the proper person. This makes the second power of attorney valid and effective both under Section 85 and Indian Evidence Act and Section 33 of the Registration Act. The only question is whether the second power of attorney was effective to render valid the transaction of sale and registration of the document both earlier than the power of attorney. In our judgment, it would be so. Mr. Hardev Singh does not read into the matter the fact of ratification by Vernon Seth Sotia of his earlier power of attorney. The second power of attorney states that in express sum that the power of attorney first was defective and was being ratified. Vernon Seth Sotia had stated that in second power of attorney, the attorney that had the act of Mr. Chawla would be his act and included not only making his document but also presentation of the document. Now the law is quite clear that ratification relates back to the original act, provided there is disclosed principle, and it has been stated nowhere better than by Lord McNaughton in Knightley versus Duran, quoting Tyndall says in Wilson and Truman that an act done for another by a person through any precedent authority, whatever, becomes the act of the principal if subsequently ratified by him. It is known and well-established rule of law. In that case, the principal is bound to act whether it be for his detriment or for his advantage, and whether it is to be founded on a tort or on a contract, to the same effect as by and with all consequences which follow from that, the same act done by his previous authority. Then para 10, my lord, I will not read full, but then para 10, my lord, talks about this doctrine of relation back. Relation back of an act of ratification was expressly accepted in this case. The other cases have been summarized in the Manual of Law and Powers and Practice of Power of Attorney issued from the Council of so and so. This follows from the maxim of law, omnis habito rehetur ex mendet priori ab perpetuum. That is to say, ratification is thrown back to the date on which the act is done, and the agent is put in the same position if he had the authority to do or act at the time the act was done by him. So, a power of attorney, my lord, the defect, when you point out in a defect in a power of attorney, it always remains a curable defect, my lord, by the act of ratification. And I had read, my lord, therefore, from the Indian Contract Act the other day. Section 196 is, my lord, founded on this principle of relation back only.
Section
196, my lord, of the Indian Contract Act, which deals with agency, which includes power of attorney, my lord. Rights of persons to do acts done for him without his authority, effect of ratification. Where acts are done by the person on behalf of other, but without his knowledge or authority, he may elect to ratify or disown such acts. If he ratifies, the same will follow as if they have been performed by his authority. Then 197 says, ratification may be expressed or implied. So the option of ratification is there, man. And in my humble submission, Bomebam is now ratifying the fact that she had signed, though her name was wrongly described. And if required, my lord, all other landowners can also ratify, my lord. Now the trial court, my lord, had looked into two judgments relating to power of attorney, my lord. In fact, both of us had relied. The respondents had also relied, and we had also relied. The decisions are of my lord Suraj Lamp and Basan Nahata. Suraj Lamp, my lord, knows is a peculiar case where basically it was dealing with a problem, my lord, where properties across India and particularly in Delhi and some metros were being sold through power of attorneys. What we call a power of attorney property, I think in Delhi they call it Lal Dora property. That is to sell, to save the revenue, my lord, of paying registration costs. People sell properties through power of attorney. Absolute irrevocable power of attorney is given, and that is taken as a sale. So, in context of the Indian Transfer of Property Act, my lord, Suraj Lamp said that no, the power of attorney cannot convey title. That is the main ratio of this particular case, my lord. While deciding and discussing, so, my lord, some aspects of power of attorney have been discussed. And one aspect that comes, my lord, is that whether power of attorney holder can depose. The law is well settled, my lord. I will not open books for that. That he cannot depose of facts of which he has no knowledge. But then he can depose of facts which he knows to be true in pursuance to his power of attorney. So in a reference case, my lord, as I had pointed out yesterday, what are the issues that are required for determination? Whether area is correct, whether rate is correct. Now, there is no dispute as to area. There is no dispute as to apportionment also. There is no question of rehabilitation here. Only issue was the rate, my lord. Now, rate is an issue, my lord, which we had objected by filing an application under section 64 of the Act, my lord. Now, that application itself is also signed by this power of attorney holder on behalf of everybody. So he would have knowledge, my lord, and be competent to depose in respect of what he has stated in his reference application. Because what he wanted the court to decide is that you decide on these issues. Some documents like the acquisition notification, etc., award, etc., were filed by us. But then those documents are, my lord, part of the acquisition proceeding. These are acts of these documents, my lord, arise out of the procedure that is prescribed in the statute. There is no dispute as to those documents, my lord. What I needed to prove only was the rate and our objection to the rate. So since I myself as a power of attorney holder had instituted this reference application under section 64, therefore, my lord, he would be competent to depose in this respect. So what he had deposed is, my lord, of course, what he had deposed, if we go into that, my lord, as of now, we will have to go into the other aspects of rates, etc., which we are not going into at this stage. So my submission would be that this Suraj Lem and Basan Nahata, whatever it says that power of attorney has certain limitations, but then those limitations does not forbid the power of attorney holder to depose at all. He can depose to the extent he has knowledge. Now, your lordship had also asked me yesterday, my lord, because I was pointing out that the records had not been, my lord, made into paper book. The central government had, my lord, taken an objection that section 64 application itself was not properly filed, my lord. And the DC had, they don't know as to how the DC had referred the matter. Well, these two documents would be available on file, my lord. I'm giving a copy as of now only because I had pointed out, because when this objection was made, my lord, I had called the officers of the Ministry of Defense to peruse the court file and see that on 15 December, there's an endorsement, my lord, of the Deputy Commissioner's Office of receipt of this application. This application, my lord, also is signed at page 20 by the attorney holder by also enclosing his power of attorney therewith. Then he had given some documents as to, my lord, how, my lord, the rate should be evaluated and why it is less. So thereafter, my lord would see that on 15 January 2024,
Yes, sir.
no, my lord, it's a separate document. I handed over both probably. These are not. Lordship has got it?
Yes.
The Deputy Commissioner, as per section 65, my lord, he has to then give a statement. He sends its statement to the court for institution of the reference on 15 January, along with his statement under section 65. He gives the basis on which, my lord, he has made the award. What was the compensation paid?
So here the description of the land is there already.
My lord,
The description of the total boundary, my lord, because this came out after the handing taking over took place, my lord. After handing taking over, army was handed. This is the outer boundary of the land, my lord. This 537, my lord. We were not privy to these documents, my lord. But then only when this reference had been filed, my lord, these things had come on record. Because the award does not give, my lord, the description. Interestingly, my lord, I will point out one thing, my lord, how we are also, my lord, bona fide in that error, my lord. In serial number 53, the deputy commissioner again names my lord Tozo Obam, that dead person, my lord. Serial 53. He names that dead person, my lord, again Tozo Obam. I understand it's a bona fide error on the part of the deputy commissioner, but then the same bona fide error had happened with the drafting council also, my lord.
No, my lord, it is not
party
an
can-
error on the part of him. My lord, he has mentioned and referred what was the land, my lord, because the land belonged to Tojobam. My lord, it is not a case of that he committed mistake, my lord. So far as the entitlement is concerned, that could have been to the wife, but so far as the land is concerned, that was recorded in her husband. So therefore, the DC is not wrong, or he has not committed any bona fide error when he makes the name of, because the land was recorded in, and he is referring to with respect to that land, not with respect to a person, my lord, who is entitled to get it or not. So that to that extent, the argument of my learned friend is not correct repeatedly, that DC has also committed the wrong, my lord. No, it is with respect to the land, and the land was recorded in Tojobam. So there is a distinction, my lord, in that. I'm sorry to interrupt, my lord, but since my learned friend was repeatedly saying so about bona fide and about the mistake by the DC, and then
Okay,
therefore I had
okay,
to interrupt. my lord.
we'll look into it. Okay,
My lord,
yes.
I'm just pointing out my version of the case. Nothing more, because these are things that lordship has to take a call on. Then, my lord, if I then go on to my lord, individually, my lord, point out that they had, my lord, pointed out as to some discrepancies in signature. The learned trial court says that, my lord, I have looked into it, and he probably does so because there was no request from their side to get any evidence, my lord, in this regard, through any independent scrutiny or through other witnesses, my lord. He says that I have looked into it, and there appears to be discrepancies as far as the signing is concerned. But then he chose to overlook because these are ultimately people of a rural background. These are people doing horticulture, and discrepancies can occur, my lord. Particularly in the context that the person who has signed, if somebody has impersonated my sign, it is for me to first come and say that my sign has been impersonated. Since that had not come, my lord, he had said that I looked into this aspect and we could find that, my lord, there are no such major discrepancies, though some variation is there. Then they had pointed out at serial number 70, my lord, that one Dopey Balm, my lord, and the deed of her name is actually Dopey Basar, because the award and the other statement actually mentions her as Dopey Basar. But in the deed of acceptance, my lord, the name was written as Dopey Balm, 359. Lordship looks at 399. Is the date of acceptance, and Dopey, her name is at serial 70. And all these things were, my lord, placed before the trial court. I'm just highlighting. Not everything is, of course, reflected in the judgment.
Referring to page number?
My lord, page 413. The award and other statements, my lord, name her as Dopey Basar. She had also signed there for the power of attorney as Dopey Basar. But then in this particular document, my lord,
below her sign, the name is written as Dopi Bam, wife of Choto Bam. But then this writing below of the name and Aadhaar card number, my lord, if your lordship, therefore I also was looking to get the originals, my lord. The photocopies are there, and these writings here, my lord, below the signature is all done by the same person in the same pen, my lord. This is initially prepared, and then only on the top, my lord, the signature is taken, my lord. So it's not a substantial error as such. Then they say that serial number 12, 15, I will give a small synopsis on that because these are factual aspect with page numbers. Serial number 12, 15, 75 and 81, my lord. They said that in some place there is a LTI and in some place, my lord, there is a sign. So to what extent, my lord, doubt can be created through this, my lord, I don't know, because there is another document also which they have annexed. In that document, one person who had put signature, my lord, sorry, thumb impression in the deed of acceptance. Earlier in 2020, he had put a sign. That document is also filed by them, my lord. One document, lordship was looking into that in just before the acquisition proceeding, they took signatures of people saying that this is your name, this is your area, and this is the amount you are getting as per our estimate. In that particular document, the signature is there. Power of attorney, the signature is there. The deed of acceptance, there is a thumb mark, my lord. Now, since no specific question was put, my lord, on this aspect in cross or something, we could not, of course, through evidence record it, but then we had generally submitted that just because somebody has put a thumb impression somewhere and a signature somewhere, and both the signature document and the thumb impression document are documents filed by you, it cannot create a bona fide doubt on the existence of that particular person. That is one aspect. And there is another aspect that they had dealt with is that there are in certain plots of land, my lord, serial number 26, 46, 78, 83, and 86, my lord. In these plots of land, my lord, there were joint ownerships or co-owners basically. So among the co-owners, my lord, in the power of attorney, only one of the owner had signed. Now, my submission on this would be, my lord, that co-owned property, my lord, is undivided. The compensation they might have shared, but since it is undivided, my lord, the co-owned property, one person is competent to represent that particular property. Or at best, the share of that particular person who has not signed has to be deducted, saying that you have not signed. Then, my lord, I move on to the other aspect of the matter, that they say that 80% payment was made and then 20% payment was made. And while receiving 80%, no complaint was made. While 20% being received, no complaint was made. But then subsequently a reference application has been filed. So that is what I understand is their case. Now, my lord would see what this 80 and 20% is, my lord, would take up initially section 17 of the old act. 1894 act. Plan acquisition 1894.
Yes.
My lord, as I pointed out the other day also, urgency can be used where the land is required immediately for important projects. And therefore, what can be done is that after the declaration itself, before the award, the possession of the land can be taken over so that the project work can immediately commence. So that is the purpose of this particular section, which is now section 40 in the 2013 Act. With only one change is that the purpose for which, my lord, this urgency can be used is now restricted to some vital infrastructure and government and defense projects only. Earlier it was unlimited. Now, in this respect, my lord would see that what the collector has to do under section 3A, my lord, of 17, before taking possession of land under subsection 1 or subsection 2, collector shall, without prejudice of the provision of the section, tender payment of 80% of the compensation for such land as estimated by him to the persons interested and entitled thereto. Now, this provision has now become, my lord, in the 13 Act, it has become section 43. That before taking possession of any land under subsection 1 or subsection 2, collector shall tender of 80% of compensation for such land as estimated by him to the persons interested and entitled thereto. Now, they say that on receipt of this 80%, we did not protest. Now, my reply to that is, my lord, the Land Acquisition Act contemplates only one reference. That reference is made after the award. So when this 80% payment is tendered, this tendering of 80% is before. They say it is in September that they had tendered this payment of 80%. Then the award came on 13 November. So when this 80% amount is tendered, my lord, the right of reference does not arise at all. Right of reference arises only after the award. On that aspect, my lord, the Apex Court has already dealt with the matter that what happens in an urgency clause, that even if you tender this 80% initially, the collector is thereafter bound to give an award. This is, my lord, 2015 10 SCC 241. A long history of facts is there, my lord, but in the summary, I would come down. The findings are noted down, my lord, at para 18.3.
Yes.
Simply put, but for the statutory enablement, the action could not have been taken, ergo everything surrounding the empowerment must be meticulously performed. Possession of land can be taken on the ground of urgency if there is only a contemporaneous payment of 80% of estimated compensation. Otherwise, making acquisition vulnerable to vitiation because of Taylor versus Taylor principle. The use of the word estimated, my lord, in section 17(3)(a) de-alienates from the actual compensation. This is estimate. Therefore, legislature had used the word, my lord, estimate. They have not said that out of the award amount, you give 80% initially and later on. So at that stage, it has, though the estimated amount may still be the final amount also, but then at that stage, because award has to be made as per the provisions of the statute and award is yet to come, it still remains the legal status of that amount is still estimate till finalized in the award. So the use of the word estimated in section 17(3)(a) delineates from the distinction from actual compensation, and estimate always remains a rough or approximate calculation only, putting Black's Law Dictionary, or an approximate judgment and of a price specified in which it is likely to be charged. It would do so. It would do violence to the statute and fly in the face of common sense if an estimate is treated per se as an calculation. Any doubt that may remain in the immediate that may remain is immediately dispelled from the perusal of section 17(3)(b), which clarifies that the estimated amount tendered under section 3A would be taken into account for determining the amount of compensation and thereafter logically permitting the shortfall or excess to be adjusted. In other words, the amount of compensation has to be determined and computed under the relevant sections of section of the LA Act. So the necessity of passing the award after the estimate is there. And only after an award is passed, my lord, a reference can be made. So at the stage when, my lord, estimate is paid in the urgency clause, this 80% is paid, there is no right of reference that accrues. Right of reference, the statute gives only after award, not after 80%. Had that been so, my lord, legislature would have said that after 80% also you should protest and lodge a reference, my lord. Then this has been, my lord, cited and elaborated in a larger bench judgment, my lord, in Delhi AirTech. Recently in 2022 SCC Online. 2022 SCC Online SC 1408. Para 13 and 14, my lord. That apart from subsection 4 to section 17 of the 1894 Act, it provides the discretion to the approving government to waive the application of provision of 5A and make declaration of so and so.
Yes.
Then para 14 is more clear, my lord. Insofar as para 14, my lord. Hence, insofar as payment of compensation for acquired land, even if it is acquired under section 70, now 40, my lord, it is evident that an award as contemplated under section 11 is required to be passed, and so as to determine the compensation payable. Subsection 3 of section 17 mandates payment of 80% compensation, and such amount would get included in the amount determined and offered through the award. And then, my lord, in paras, I think 19 thereafter again Lakshmi Devi is referred to. So I had already read Lakshmi Devi. So my submission is that, my lord, when this 80% is tendered, the right of reference does not arise, my lord. The right of reference, my lord, arises from, my lord, the award only, because the language of section 64 is clear that any person who is interested and not accepted the award may by written application to the collector. The word award is here. Here the word is award. In section 40 it is estimate, my lord. Had the word been award also in, my lord, section 40, a right of reference would have arisen. But then the statute says, my lord, your right of reference will accrue only when the award comes. Now 64, my lord, was already read by the
No,
learned
in
AC.
this section, the word payment is not there,
My lord.
accepted the award.
Payment is not there. Payment is again in section 77. Earlier it was 31, and now it is in 77, my lord. That after the award, the collector immediately has to tender the payment. Unless he is prevented by a situation where apportionment dispute comes in.
After the award, they can, after receiving the 80%, and other amount also, you have not raised any objection.
No, that I'm coming to, my lord. 77 again says, my lord, payment of compensation. It does not have reference, my lord, to section 40. 77 says that on making of an award under section 70, the collector shall tender payment of compensation. So the payment of compensation after award only creates a right of reference, my lord. Not before, at the stage when, my lord, payment of 80% of estimated amount, because at that point of time award has not come. At that point of time, no reference right accrues, my lord. Now, the question, my lord, that was raised here is that the proviso, my lord, provided further that no person who has received the amount otherwise than on protest shall be entitled to make an application under subsection 1 of section 64. This, my lord, was earlier section 31, my lord. The same language is there. Section 31, my lord. The second proviso here also, provided that no person who has received the amount otherwise than under protest shall be entitled to make an application under section 18. So what we had argued before the reference court is that what is this protest, my lord, that is contemplated? Is it a protest in form of an hesitation? Is it in form of a written application? The statute does not say anything about how this protest is to be lodged. Whereas, my lord, as far as a reference application is concerned, it has to be a written application. Now, this aspect, my lord, has been dealt with in a number of cases, my lord, which are already cited in the reference court judgment. I would invite your lordship to have a look at the relevant cases. These are short judgments, my lord, very short. I'll just read the relevant part. Ajit Singh. Andravan. And SK container. Container. I believe this interpretation, what I am going to read, has come because we are talking about a substantive right here. Substantive right cannot be by virtue of interpretation be restricted, my lord. It has to be, my lord, enlarged. So that is why I think para 5, my lord, initially of 1994 4 SCC, 1994 4 SCC, page 67, para 5, my lord. It says, in as much as the appellant's an application for reference under section 18 of the Act will manifest their intention. Therefore, the protest against the award of the collector is implied, notwithstanding the acceptance of compensation. So why would I, first of all, my lord, as a landowner, not receive the compensation? My land is gone. Maybe you're paying me less, but then why should I not take it also? Because my land is gone, my livelihood is gone. I will take it. Then I will take my chance of, my lord, getting through a procedure of law, if I am entitled, if I can establish in the court, a higher compensation. That remedy I will avail. Then the same is, my lord, reiterated, my lord, in para 11 of 2015, 15 SCC 343. This is by a larger bench, my lord, of 3 judges.
Paragraph number?
My lord, I will refer to para 11. This also falls back on Ajit Singh again. But then a larger bench is now upholding Ajit Singh, my lord. The principal contention urged by the Learned Counsel for ZDA was that since compensation was accepted by the claimants without any protest, the reference was not maintainable. In our opinion, this contention is without any substance for several reasons. In Ajit Singh versus State of Punjab, it was held that since the appellants herein had filed an application for reference under section 18, it manifested their intention. Consequently, the protest against the award of the corrector was implied, notwithstanding the acceptance of compensation. Then SK Containers, my lord, again in fact, gives a more elaborate description as to this, my lord. In 2017, 4 SCC 3 to 6. But you would come to para 3 and 4. We also find that land acquisition collector passed the award and the appellants in fact had filed an application under section 18 for enhancement of compensation. Section 18 reads as under. Para 4, once an application under section 18 is filed, the presumption under law is that the owner of the person interested in the land has certain objections with regard to measurement of land, amount of compensation, persons to whom it is payable, and apportionment of the compensation. Admittedly, the appellants have filed an application under section 18 of the Act, and therefore it is for them to pursue the said remedy. So 18, reference being a substantive right, my lord, the right of a party to seek reference, my lord, cannot be washed away by simply saying that you had to protest, where the Act itself does not define, my lord, what that protest has to be. So it is understood that why should a application for reference be filed if there is no protest? Only thing that is to be seen is that it has to be filed within a period of limitation of 6 weeks, which now can be enlarged to some extent by the deputy commissioner if sufficient reasons are there. Now, interestingly, my lord, this point, my lord, was also urged very vociferously, my lord, by the Union of India in a identical case, my lord. In that case, my lord, another AAZ, Mr. Banerjee, was appearing. The Union of India, my lord, had one of the contention. There also, my lord, it was a case, my lord, filed for a power of attorney. They initially raised some issues about the power of attorney. Subsequently, my lord, again abandoned it. But then one of the main thrusts of that particular case was that it was also a case, my lord, of acquisition of land at Mechuka, my lord, in a nearby district for the Ministry of Defense Army. 3 pockets of land were acquired. It was also under urgency clause and section 80 was invoked. Section 80, my lord, we received compensation. After receipt of the award and the 100% compensation, a reference application was filed. Now, the reference court decided the issue in affirmative in our favor. The matter traveled to this High Court, my lord. There were 6 appeals. There were cross appeals by us also. On 27/2023, this honorable court had decided the matter. And if your lordship goes to para 40, this is a judgment, my lord, rendered in LA appeal number 1, 2, and 3 of 2022. My lord, see, Vazit Singh, that I had cited now, Chandrabhan, and SK Containers are all cited here. And the reference was accepted. Now, there's a twist to this, my lord, also, that this, after the reference court award was, my lord, upheld by this honorable court, the Union of India went to the Supreme Court, my lord. So this particular issue, again, they have urged in the SLP. This is, my lord, the order of the SLP. This is pending as of now. It is yet to be admitted. Notice was issued, my lord, on 22/9/2023. Issue notice returnable 4 weeks. Mr. Pathak, learned counsel for the respondents, appear and accept notice for all respondents. The court has an equity by saying that give 50% of the amount, which will be withdrawn with security. The SLP, as on points of law, is yet to be admitted. It will come up someday, my lord. But then this particular issue is maybe alive in the Supreme Court also. I would therefore, my lord, not like to anticipate as to what would happen there. But then I was expecting that then since this issue, and in fact, all the subsequent issues that come as to enhancement, as to government notifications which fixes, my lord, land rates in Arunachal, as to the aspect relating to, my lord, multiplication factor, everything was dealt with in this judgment, and the Supreme Court is in session of this matter. Now, since probably, my lord, this order had given a 50% deposit, the other day when we argued, my lord, the matter relating to the stay of execution, based on this precedence only, my lord, the learned judge had said that, my lord, the 50% is to be deposited because that is the norm normally followed. And since the point of this fraud and other aspects of the matter will also, my lord, vociferously argued at that point of time, resisting the deposit, I see that they now intend probably to challenge that interim order or that order of 12th March, my lord, in the Supreme Court. So the other issues, my lord, during pendency of that particular SLP, my lord, I would leave it to your lordship how to tackle it. There is another aspect here, my lord, which probably they are not highlighted. Lordship had seen probably there was a sanction letter of the government of India as far as this particular project is concerned. There the multiplication factor was given as 1 based on a 2015 notification. That 15 notification also, my lord, is under challenge by the Union of India and Supreme Court. In that case also, my lord, 50% has been paid and Supreme Court is hearing the matter that is in the final stages of hearing, my lord. So as far as these notifications are concerned, the Supreme Court is in already seized of some of these issues, my lord, that are there. So the court had, of course, followed the precedents because what we had stated, my lord, is not just based on this particular facts of the case, but then the law, my lord, as far as protest is concerned, as far as enhancement of compensation is concerned, is more or less settled. Only thing that is to be seen is that whether our case fits into those facts and circumstances or not. But then these are the two things, my lord, I thought that should be highlighted, and these two aspects are, my lord, pending in the Supreme Court as of now.
Okay.
So
Any
since
other
only since only these 2 points were ours, my lord, by the learned ASG, I would not go to any other point, my lord, as far as the other party is concerned. But then I would only reiterate, my lord, that these 2 points probably, since the reference code itself did not have actually jurisdiction to go deep into these points, because its jurisdiction, as I pointed out, is confined to a exercise, my lord, in which he only finds out the rate. If he does so, if these issues are brought out, my lord, if the reference code did not have jurisdiction, how can the High Court also, my lord, now say that reference code ought to have looked into these things? This is one difficulty I find, my lord, in this matter.
Okay.
My lord, 142 have filed the IA. I think that order is not passed regarding
it will be
extension
uploaded
of
today.
deposit, my lord.
Uploaded today?
141.
Yes, uploaded today.
Yeah,
Oh, my lord. And my IS, my lord, one was by Bomebam, as I had said. Just take 1 minute. Bomebam had said that I am ratifying, my lord, my signature there. And she says that description of parties can be corrected. That is her stand. The other 2 IAs are, my lord, for calling of the records from the Deputy Commissioner as far as disbursement is concerned, because the authenticity of the persons and the future scam that might happen in this matter is being raised. So whether these payments were properly authenticated earlier or not, the reference code, the deceased record would reveal. Since that has been brought in as a very live and pertinent question, my lord, in this matter, that record may have to be looked into. And the original exhibits, my lord, as of now, since question of comparison of signature, etc., and so many other things are there, including the dispute in date in the deed of compensation, where the DC had filed it as 1st of November and the union's document is not dated, but then their document has an endorsement in the back, my lord, of a stamp of 28th. So therefore, I had said that these documents also might have to be looked into, my lord,
Then we have to call for the record.
My lord, that is why these are the applications for calling for record, my lord. Because if your lordship tomorrow comes to a finding that, yes, these discrepancies are genuine and ought to have been looked into, and the reference court also has a jurisdiction to look into this. That has to be based on the exhibits. Normally, all exhibits originals are to be kept in file as per order 12, my lord. But in these cases, my lord, they had produced only some photocopies, and I don't know what was the origin, because we had not disputed as such those documents. But then since the question of comparison, my lord, had come in now of the genuineness of these documents and the dates and signatures therein, it would be better if the court takes seize of these documents and calls for the same, my lord.
The problem is that tomorrow is the last date.
My lord, my
of
lord,
this court.
I understand. The outlying means is, my lord, this is a difficulty, my lord. The judges keep rotating. But then I consider, my lord, that might be necessary, my lord.
Okay, we will see if necessary. We will list the matter again in the spoken column, to be spoken column. Thereafter, we will consider it.
My lord, and as far as my submission is concerned, lordship had asked me to give a small synopsis that I could not prepare, my lord, because I don't have an office here. But then as far as the evidence is concerned, lordship,
Prepare the synopsis, but the list of
the evidence, lordship, since it has not been properly prepared, I am supplying a copy of the evidence.
okay, but the list of judgments you have relied upon,
My
you
lord,
also give it.
I'll file it at my lord.
Only the list. You can
Within
give
a
the-
week, my lord, I'll send it to the registry here.
Yes, yes.
These are the copies of, my lord,
Evidence.
evidence, my lord, of there is one PW, and my lord, there are 4 DWs. I have marked the cross-examination and chip. And DW2 I am relying upon because he is the person who, my lord, made this pleading, and thereafter he did not say anything about in the evidence, my lord.
Okay. Yes, Mr. Sanjay, anything to submit?
Lordships, I have to respond to my learned friend's argument because, my lord, he has made the argument of, my lord, Evidence Act, my lord. He has not said about 106 of the Evidence Act, my lord. That is when something is within the special knowledge of a person, the onus is on him. It was not that case, my lord. Our case is right from the beginning how the fraud has taken place. And now my learned friend has filed an application on behalf of the late wife, my lord. Now, my lord, how the notary public can authenticate a dead person, my lord. Now everything is purported with fraud, my lord. So I have to say many things, my lord, in response to what my learned friend has tried, my lord, very lucid argument by my learned friend has made to show that all these are procedural irregularities which can be rectified. No, absolutely not, my lord. It goes to the very root of jurisdiction, my lord. And what my learned friend has said that a reference court could not have gone into it. My lord, I'm just giving one example, my lord. Now, suppose there is a criminal case in which there is one accused, my lord. Now, my lord, some third person who may be inimical to the accused, he goes and executes a wakalatnama in the name of that accused person and files an anticipatory bail application in the court. And the court, my lord, the main accused even does not have the knowledge and the court rejects it, my lord. Now, my lord, because the court cannot go into the question whether it has been filed by him or not. Now, such cases of fraud are coming very frequently to the high courts and supreme courts. And therefore, most of the high courts have now issued a direction that the persons who are swearing the affidavit, they will personally visit and then only they will sign and then they will be identified. My learned friend has made his argument and he has talked about authentication, my lords. Now, my lord, in the present case, neither there is authentication of the document, my lord, power of attorney executed, nor, my lord, there is any authentication by the witnesses, my lord. Now, he said that it is only, my lord, a rectifiable error, my lord. No, it's not an error. Now, if your lordship will see, kindly see, my lord, the Evidence Act, my lord, section 106 of the old act, my lord. Now, kindly see, my lords, my learned friend was referring to the Evidence Act and he read section 101, my lord, but he has not read section 106, my lord. Now, kindly see Section 106. My lord, rightly fallen from my lords, my lord, that if something is brought to the notice of the court cannot be a silent spectator, my lords. Now it says burden of proving fact, especially within knowledge. Now, my lord, it was only specially within the knowledge of this power of attorney holder and the my lord, notary public, my lord, to prove it. Once this was brought to the notice that they have the court, reference court had no jurisdiction. Now, my lord, therefore, now lordship will kindly see when any fact is especially within the knowledge of any person, the burden of proving the fact is upon him. So the initial burden was on them. Now, my lord, this issue was raised, my learned friend has shown to this honorable court that we had raised this issue. And in the my lord, in our written statement, if your lordship will for the moment see our written statement. Written statement, my lord, our written statement is at page, my lord. My lord, that is copy of reference petition. Our written statement is at page, my lord. Your lordship will see it starts from page 2, 283, my lords, annexure P4. At the relevant place, that your lordship, we have in paragraph 10. Paragraph 10.
Yes.
Now, my lords, in para 9, it was clearly mentioned that the special power of attorney submitted by Sri Dagli Diba was signed on 9/11/23. Now, my lord, my learned friend has raised the issue about after the award only. Now, my lords, this 9/11, my lord, I had at the time of my initial argument, I have shown to my lord that in the power, so-called power of attorney, on the basis of which the reference has been preferred, my lord, the date is mentioned under the signature as 7/11, my lords. And here it is 9/11, my lords. This was before the reference court and duly pointed out. And my lord, it was also pointed out that some out of them is not known whether all the grantors are alive or dead, my lords. Now, my lord, this was a matter, once it was brought to the court. Now, since this was within the special fact, it was a special fact within the knowledge of these persons, my lord, this power of attorney holder, it would first he had to discharge the burden that no, it is correct. Now, my lord, then my lord will kindly see, my learned friend has just brushed aside our objection, which was a very strong objection with respect to the signatures. My lord, the signature, my lord, directly goes to whether they have at all any knowledge that any power of attorney has been executed on their behalf or not.
Mr. Sanjay, the
Lordship.
plea of this fraud is taken by you.
Lordship.
So
My lord.
therefore,
My lord,
in view of the
no, my
decision.
lord, your lordship, that's correct, my lord. The plea of fraud I have taken
So
because
you have to discharge your burden.
Definitely, my lord. But then once we have brought, my lord, while making the allegation of fraud, we have brought on record his document. We have not to bring any document. My lord, if we would have alleged any fraud on the basis of any document which was he having contrary to his document with us, then definitely we had to prove that because we were alleging. But we are saying that the document of power of attorney itself, fraudulent document, it's forgery and fabricated document. And for that purpose, we have shown to your lordship, yesterday, my lord, I had handed over, my lord, a list, my lord. If your lordship will kindly see the list, my lord, that list. Yesterday, which my learned friend, Mr. Doroy, has just handed it over, my lord. Just kindly see for your lordship's satisfaction, my lord. 14 points, my lord, which was there in the very documents itself, my lord. So, my lord, that is on record, which was pointed out to the court. So they had to disprove it, my lord. Because these are on the face of a sheet, staring the face of them. And this was within the special knowledge of the power of attorney holder only, not others. In terms of section 106 of the old Evidence Act and 109 of the present Act, my lord. Yesterday we had given, my lord. It's just 4-page, my lord. Lordship got it, my lord. Now kindly see one.
No,
It is 14 points, my lord. My learned friend has given yesterday, my lord. Mr. Doroi had given.
any extra copies available? with
Yes,
you?
my lord, I'll just this pending out, my lord.
It might be with the IA file, my lord, because it was submitted in connection with the IA. So probably it has gone with that IA that your lordship has reserved the order for today. That extension of time.
My learned friend will just hand it over, my lords, to your lordships, my lord. Only, my lord, till my learned friend hand it over, my lord, lordship will just permit me to place it, my lord. These are, my
Yes,
lord,
yes.
not on the basis of any document supplied
got
by
it.
us, my lord. Lordship got it, my lord?
Yes.
Yes, got it.
Lordships. Now your lordship will see first point, my lord. Power of attorney was forged and fabricated and it has been shown to be executed by a dead person. This is number one, my lord. Namely, Tojo Bam at serial number 53 in the power of attorney and at serial number 53 in the reference application. Though he died on 10/6/23, my lord. Now, my lord, this fact was
Page two,
a fact
Got it.
page two, the following reasons.
which was not required to be proved, my lord, because admittedly she is a dead person. He is a dead person, and my lord, his wife took the 100% compensation. So therefore, the reference was to be filed by the wife in her name and not the dead person. And that too, my lord, after authentication by a notary public. So this fact was a glaring fact on the face of it, my lord. Lordship.
Mr. Sanjay, today Mr. Pathak has addressed this issue.
Lordships. That's correct. So therefore, I am responding to that this fact was, this need not be proved by us because this was within her special knowledge, the special knowledge of the power of attorney holder that he is being appointed and a power of attorney of his wife or the dead person, my lord. Now he is taking the plea of typing error, my lord. My lord, can it be said so, my lord? When subsequently, now, my lord, I have given the sequence of event, my lord, that on, my lords, on 9th November, my lord, the so-called power of attorney is shown to have been executed. And, my lord, on 23rd November, the settlement deed is signed in which my lord, the power of attorney holder has also signed, my lord. So this could not have been that the power of attorney holder will be a dead person, my lord. And this was merely a typing error, my lord. So this is number one on the face of it, which was a proven fact, has been, my lord, if that fact was brought to the notice of the court, it was the duty of the reference court to look into it, my lord, and to ask the power of attorney holder that how could he be authorized and he is authenticated by a, my lord, power of attorney holder. Now, number one. Number two, my lords, that no individual landowner has executed it. Rather, my lord, narration page, a table with 3 columns was mentioned. No, my lord, no schedule, my lords. Now, my lords, my learned friend has argued today that when the land was verified, thereafter, the collector has sent it to the my lord, reference court, my lord. But then here, in the power of attorney, admitted position is that no description of land, no address of individual power of attorney holder, my lord. Absolutely nothing. Simply on one page, my lord, the reference court has itself said that so far as the settlement deed is concerned, on first 2 pages there were the narration and thereafter a table, my lord. Therefore, it can't be relied. But so far as the power of attorney is concerned, same thing was there and he relied on that, my lord. And on that basis, he assumed jurisdiction to decide the reference case, my lord. Identical situation in both these things, my lord. If your lordship would like, my lord, I would like just show to that document, my lord, the settlement deed, my lord, in first and second page, there is narration. Thereafter, table form,
Yes,
wherein on this photograph of all the landowners with their signature, their address, their Aadhaar number is there.
Mr. Sanjay, you have already shown that document to me.
Your lordship, your
Is it
lordship. Then, my lord, then,
necessary to repeat the same thing?
lordship. If lordship have understood it, no difficulty, my lord. Now your lordship have recollected it, my lord. Now, my lord, then third, neither the complete address nor description of land of each landowner for which power of attorney was sought to be executed has been found mentioned, my lord.
Mr. Sanjay, you have already argued on this point. No necessary to
Lordship.
repeat the same again.
No, my lord, I'm not arguing, my lord. I have enlisted, my lord, 14, my lord.
This list,
I know,
this list is available with me now. I will go through the same.
Lordship.
necessary
So therefore, my lord,
to repeat
on
the
the
same.
therefore, on the face of it, my lord, these were the facts which were within the special knowledge of the power of attorney holder. Therefore, the burden was on him to discharge that no, he is the actual power of attorney holder and these attorneys are genuine, and he had to bring them, call them in dock, my lord, to depose that they have adduced it. They have signed on it. Because, my lord, the authentication is found to be false, my lord. The authentication is of not a person, my lord, even one, my lord, dead person, if authentication is there, my lord, the whole authentication is on one paper, my lord. Had it been individual, it could have been said. But it is on one paper, one of 102 persons. So therefore, the whole authentication is, my lord, in view of the date, in view of the signature, in view of the absence of any witness. So it is between the attorney holder and the notary public, my lord. Just between the two persons,
Okay.
everything has been done and preferred. And my lord, the learned
Okay.
court has just
Yes.
brushed aside these arguments.
Okay, all right.
So, my lord, these are the basic arguments on, my lord, fraud and, my lord, no protest, my lord. The argument of my
Yes.
learned friend on protest is, my lord, completely divorced to the provision of section 64 and 77, wherein, of course, no mode is prescribed of protest, but then the protest has to be at that. Subsequently is only the reference application. Therefore,
Okay.
this was
okay.
required to be
Just-
considered by.
Just one line, my lord. I am aware of 106, my lord. But then I pointed out that as far as agent and principal is concerned, there's a special provision in the Evidence Act. That was in, my lord, section 109. Now it has become, my lord.
109.
Earlier it was 109. Now it has become, my lord, 112. Since there is a special provision as far as power of agency is concerned, my lord, this provision would override 106. Had this not been there, 106 would have governed that whatever is in your exclusive knowledge, it is for you to establish it. But then 111 says that if your agency is questioned, the person making that allegation has to prove it, my lord. The onus is on him, my lord.
My lord, the evidence is already there on
Okay.
record, my lord. On the
Okay.
basis of which the reference court has assumed the jurisdiction. Very good.
Sanjay Learned, Additional Solicitor General for the appellant, assisted by Mr. Y. Dolo, Learned Senior Counsel for the appellant, and Mr. Pathak for the respondent. Respondent number you were for?
It's 100 and there are 102 persons, my lord. These are the private landowners, and thereafter there's deputy commissioner and the state
For
government.
Deputy Commissioner, who is it?
Mr. Ansari is there, my lord.
Mr. Ansari for respondent number?
I'm only appearing the LA number 4.
104.
Deputy Commissioner, LA appeal number 4. Otherwise, in LA appeal number 1, I'm not appearing on behalf of.
So you are only four,
4,
not in one.
not in.
Who is appearing for one then?
Here I'm appearing for respondent number 105. by state.
In LA one.
Yes.
Mr. Soki for 105.
Five.
Madam Sangita, you are for Deputy
The
Commissioner?
PC can be represented by a government advocate.
Ms. Sangita for respondent number One zero four. And 105,
I'm representing 10.
Mr. Soki for respondent number 105. Argument concluded. Judgment reserved.
It has become 103 because they have repeated one name twice actually. That is why 103 persons it has become.
Pardon?
They have repeated one name twice, my lord, in a memo of appeal. That therefore, actually there are
My lord,
102 persons, but then it has become 103. Anyway, my lord.
In fact, my lord, my friend is also, my lord, representing, my lord, Dudley Riba as a power of attorney holder of himself, my lord. It has been mentioned that they are all being represented by power of attorney as if that he has given power of attorney to himself, my lord. My lord, only one fact, my lord.
I don't know. I
I
don't know
wanted
if
to
my
show to my
authority or
lordships,
argue
my
also
lord.
is questioned, my lord.
My lord, only one fact, my lord, I wanted to show to my lords, my lord, from the record, my lords. If your lordship will just have pleasure to see, my lord. In the if your lordship will see in our written statement, my lords, annexure 4, we had specifically, my lord, raised the issue in paragraph, my lord, 10 at page 289. My lord, page 289, we have specifically said about that thus the same cannot be entertained by this honorable court and same is liable to be rejected and investigation is required to be ordered, my lord. If your lordship will see page 289 for a moment, my lords. My lord, just before para 11, my lords. Just three lines above. But from the above, it is clear that the so-called power of attorney is not a genuine document having legal validity and not executed by ex-landowners. Thus, the same cannot be entertained by this honorable court. The same is liable to be rejected and an investigation is required to be ordered. So we have raised that issue, my lords. And thus, once this issue was raised about the very power of attorney and reference to be maintainable at the instance of the power of attorney holder for 102 persons, my lord, then it was the courts to also to see, my lord. It should not have been a mook spectator to just brush this aside. And in support of this, my lord, document was also shown to the court, which was already on record. That was the power of attorney.
Okay.
So therefore, my lords, and my lord, one more fact on instruction, my lord, I am stating before your lordships, my lord, with respect to the land acquisition case, my learned friend has just now stated, my lord, I am on instruction, I have been told, my lord, that the amount of 50% has been deposited, which has been withdrawn by the power of attorney. And thereafter, where it has been gone is not known. So the power of attorney has withdrawn that money, my lord. On instruction, I am saying to your lordship, this fact, my lord. So this is not new.
That the Supreme Court matter that I have referred to, my lord.
That the matter which is pending, in which, my lord, that direction has been issued, my lord, to deposit 50%.
That they can raise in the SLB, my lord, if they are
the
agreed by that.
money has been
They have to raise
already
it in the
withdrawn by
SLB,
the
my
power
lord.
of attorney holder, my lord. My learned friend was saying that power of attorney does not have power. There, the power of attorney holder has withdrawn the money, my lord, on behalf of all of them, my lord. In LA appeal number, my lord, 1, 2, and 3 of 2022, my lord. So therefore, my lord, it is, my lord, public.
Before this court now.
Yes, my lord. It's before the
no,
Supreme Court,
I
it should be hesitated
Okay.
there if anything is there.
Oh, okay. Yes, any other matter?
The question is of such huge amount, my lord.
My lord, to have be given a week's time, my lord, to submit that, my lord.
I will. My lord, we will also submit, my lord. I will also submit, my lord. A written, my lord, submission to that effect, to this effect, my lord.
Who objected our worker? They say you are not the party in a reference case. That's why the matter was not. Otherwise, our appeal was simultaneously with the.
No, it was filed simultaneously, not admitted because, my lord, section 74(1) says requiring body, that is Ministry of Defence, they can file an appeal or person aggrieved by the award passed. Now, person aggrieved is again defined in the act as the person who is to receive compensation
Mm.
is the only person who is aggrieved. So the landowners and the requiring department are the only parties permitted by the statute to file appeal.
Mm.
So they can be heard only as a respondent in the case that the union has filed. They have a right of audience definitely, but not in an independent appeal, my lord. Probably to avoid multiplicity of appeals, my lord. What is the point of filing 3 appeals? If all parties are there in one single appeal and as the respondents also, they can submit in the matter. If any grievance is there or any point is to be made, my lord.
So this appeal has not yet been admitted.
Not
No,
admitted,
the
my
bill
lord.
is not yet.
Court.
More or less same.
I'm sorry, my lord,
And they
the
have
interpretation.
not implemented defense status party. They have not implemented defense state as a party where additional solicitor general is appealing. They have to implement also.
Mm.
Question of implement would come firstly, my lord, whether it is to be admitted or not, my lord.
Okay,
My lord, the
tomorrow then we
interpretation
will
of
hear on the question of
That- but-
maintainability of this petition.
Our part of argument.
No, my lord, there is no difficulty with regard to the maintainability, my lords.
My lord.
They challenge our democracy.
My lord, they are also
Mm.
aggrieved person, my lord. It's not only the requiring body which is an aggrieved person, my lord. Even the state, my lord, or the DC is also an aggrieved person, my lord. The definition of aggrieved person cannot be restricted only to the person, my lord, who are seeking compensation, my lords. Any party who was party before the reference court is aggrieved can prefer an appeal before the High Court.
So Mr. Sanjay, you are not a party in this appeal.
So that they should have been made, they should have made us party.
No, now you have no locus to argue the matter until and unless you are being implemented.
No difficulty. I was just mentioning about the law, my lords, not in this case, my lord, because I am not a party, so I can't. But only as a question of law, my lord, that I was assisting my lords, my lord, that if the person interested cannot be, my lord, confined to the meaning that only the landowners or the requiring body can prefer an appeal. My lord, any person who was party, if he is aggrieved by the judgment, can.
So do you have any decided case on this point?
I will, my lord. I will, in order to assist my lord,
So
I can do it, my
tomorrow,
lord. I can do it.
You send it to Mr. Doloi. Mr. Doloi will submit it
Lordships.
tomorrow. Okay.
I'll do it.
Item
10, my lord, the union is a part.
Item.
The state revenue department also have filed an appeal.
State is also filed. Item 10.
Same issues, my lord. My thing is that irrespective of maintainability, my lord, why multiplicity of appeals, my lord? If as a respondent also you are entitled to argue as if you are an appellant. CPC provides for that.
No.
The respondent also can present his
Sir.
case as if he is an appellant.
No, Mr. Pathak,
My
the
lord.
problem is that we have already concluded argument in the main.
My
appeal.
lord, my lord. So independent hearing of these two are not required, my lord, as of now. Probably. Because if they have anything
Okay,
to say
that's
on
fine.
merits,
Tomorrow we will
my lord,
hear.
we will deliberate on this, my
Tomorrow.
lord. We'll deliberate on this, my lord.
My lordship is fixing this
Pardon?
case tomorrow.
Yes. No, Mr. Sanjay, we will not hear you tomorrow
Acha.
until and unless you are being implicated as party in this proceeding.
Lordships.
Okay, even then,
Grateful, my lord. I'm
you may
deeply-
send any decided case on this point or to Mr. Doloi.
Oh, yes. I will,
Okay.
my lord, in order to assist, my lord, it's my duty to assist this honorable court, my lords, and I will do that, my lord. I
Yes,
will do
yes,
that.
yes.
My lord,
Yes.
only one request, my lords, that the interim order which was passed yesterday, that has not
No,
come, my
no,
lord.
it is being uploaded today.
Lordships, grateful, my lord,
Yes.
grateful.
Yes.
Now, my lord, so far as, my lord, this case is, this part is concerned, which my lords have heard at length, your lordship is, my lord, reserving the judgment, my lord, order on that, this issue? Or
Which
it
one,
will
in
be?
appeal?
Yes,
No,
your
no,
lordship.
we have already dictated the order. Judgment is reserved.
Acha. I'm grateful. I could not hear, my lord, perhaps.
Okay, okay. Raises a list the LA appeal number 4 and WPC number 492 AP 2022.
No, not
Tomorrow.
WPC.
This is separate.
It's separate.
The other item number 10. Item number.
Should be 3 and 4. Appeal number 3 and 4. Maybe let's shift tomorrow.
3 and 4 tomorrow.
Obliged.
I'm grateful, my lord. I'm deeply grateful.
Okay. Mr. Modi.
We have consumed some additional time today. We have. Obliged, madam.
We'll try tomorrow. If not possible, then we will release it from Partat. List this WPC number 492 of AP 2022 tomorrow. You take it that from him.
Lordship, this I need to make correction of the course title. Only course title.
Pardon?
Course title. Correction of
Amendment.
yes.
Who said that?
17, item 17.
Hard Mr. Your good name?
Keith, I mean,
Learned counsel for the appellant.
yes.
And anybody for respondent? Additional PP? No, none appears for the respondent on call. The learned counsel for the petitioner submits that there is some typographical error in the memo of appeal, and as such a price for allowing him to amend the appeal. Memo of appeal, there is accordingly allowed. The counsel for the appellant shall file amended appeal within a period of 1 week from today.
Lordship, after 2 weeks.
So it's okay.
Duly Lordship.
My lord, may I make mention to item number 12 and 13? May I pray to list this matter after
3 weeks. Okay, Mr. Oyang, learned counsel for the petitioner. Press for listing the matter. Item number
12 and 13?
12 and 13 after 3 weeks.
After 3 weeks.
Okay.
Online.
My lord, may I pray that item number 7 may be listed on 11th of this.
11. Mr. T. Soki, learned counsel for the petitioner.
I'm for the petitioner.
Press for listing the matter. Item number 7. On
11th.
11th of the pair alone.
All right.
Lordship, I may mention for item number 8. This matter was fixed for today, but so may kindly fix for tomorrow, Lordship. So there's
So
not.
may not be possible because several matters have been fixed.
Yes, Lordship.
Yes, Your Lordship. So, Your Lordship, this matter may be listed on Wednesday.
Next Wednesday?
Yes, Your
It was come up on Monday for motion.
Lordship.
However,
On Monday, my senior who is appearing in this matter, Mr. R.
Item number 6.
8.
8.
Kindly this matter. will be
Okay, as agreed by learned advocates of both the parties, recess shall list the matter on
Wednesday.
Wednesday.
Yes, sir. Much obliged.